Oh, please mute, Carlos.
What?
It said please mute so they can't hear our background. Yeah. Oh. Say the meeting is now streaming, but we ain't got nothing.
Where's ATL?
The alt button.
Yeah.
I can't see nothing. Did you read it?
Huh?
The host had to mute us.
The Carlos Young Street. Please go ahead and mute this.
Mute.
Good morning, ladies and gentlemen. We are going to begin with our state all-purpose calendar. This is the State Court of Fulton County. This particular calendar involves cases in which individuals were accused of misdemeanor offenses. Today, we're going to get a status of those cases as to how the defendants would like to proceed. We are going to determine if the defendant would like to accept a plea recommendation from the prosecutor, which is the Solicitor General's Office of Fulton County, and consider entering a guilty or no contest in exchange for a recommended sentence. Otherwise, the defendant has a right to plead not guilty and have the case further noticed for trial. In either event, if you are a person accused of a misdemeanor offense or offenses, please remember that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. For individuals who are not defense attorneys, but you are a family member or a victim or a witness, please keep your Zoom panel in a muted and also stop your video. You can start your video and unmute when you hear the party you're interested in addressing called and being addressed by the court. But presently, please make sure that your Zoom panel is on a stop video and that your screen is muted. Thank you. The only exceptions would be attorneys and individuals who are part of the courthouse staff or probation or revocation staff members. Thank you. So Ms. Deidre Thomas and Ms. Chandra Little, please stop your video. Thank you. All right, courtroom 2, who are we addressing first?
Oh, okay, I'll have this. Can we go to the probation calendar?
Sure.
1 through 4. Probation 1 through 4. Yes.
Good morning. We are recommending time survey. Okay. Time survey. I have a call here probation. Okay.
All right, good morning, Ms. Vigiletti. Who do we have for the present time, 1 through 4?
Yes, this is Mr. Irvin on the probation calendar.
All right, thank you. Good morning, Mr. Irvin. My name is Judge Lal, and we're going to address the cases in which the state is seeking to revoke your probation. Please remember that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Vigiletti. Position 1, let me see. Let's go with the underlying cases first. They're listed on positions 3 and 4. 23 CR 2133A, Mr. Irvin was convicted of theft by shoplifting. And on position 4, 23 CR 2224A, Mr. Irvin was convicted of 1 or more charges of willful obstruction of an officer. You have 2 probation revocation cases, 24 PV 652 and 24 PV 653. Mr. Irvin, the probation officer, Mr. Barnes, is going to indicate the reasons why they're seeking a revocation and the state's recommendation as to how your probation should be treated. And then I'll let your attorney speak on your behalf. Officer Barnes?
Good morning, Your Honor.
Good morning, sir. May I place you under oath?
Sure,
You solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge.
I do, Your Honor.
Thank you. All right. Mr. Darius Irvin, with regards to his convictions, what was his requirements and how is he, and why are you seeking a revocation?
Your Honor, this case was before the court on April the 13th of 2023. He was sentenced to do 12 months of probation. And, Your Honor, according to our records, Mr. Irvin has never reported to probation.
Was he required to do anything else? Any theft class or restitution?
Your Honor, if you give me 1 second, please. I'm sorry. Give me 1 second. Let me double check this. Your Honor, he was ordered to complete a shoplifting course and to stay away from the incident location.
What is the state's recommendation? How many days has he got left on both cases, and what's the recommendation?
Your Honor, he has 213 days left on this particular case. It looks like the warrant was issued on September the 12th of 2023. So it's 213 days remaining left on this case. On the case ending in 24A, he has 208 days left on that particular case. And on that particular case, he was also ordered to complete the shoplifting. I'm sorry.
I think it was count of willful obstruction.
Willful, yes.
Okay, all right. And the state's recommendations to revoke or continue on probation?
Your Honor, probation was respectfully asked that you revoke the balance and commute the time served.
Okay. Ms. Vigilante?
I'm sorry, I just to clarify, the offer I got from Ms. Washington was time served. Are we revoking the balance or is it time served?
It is giving him credit for the time and commuting it to time, giving him credit for the time he's been in jail and commuting the remainder to time served.
Okay, understood. Thank you. Yes, I will just mention Mr. Irvin has been incarcerated most of the past year. So he was in custody from June to August, and then again in September, he was in custody in Oconee County, was released to a hold in Coweta, and then released. So he has been in custody most of the past year.
All right, I'll accept the state's recommendation. Both these cases will be recorded as a probation violation. And he's been given credit for the 10 days he's been in jail, and the remainder is commuted to time served. Thank you.
Thank you, Judge.
Do we have any other probationers, Ronnie Smith or Brittany Morris?
Not in the courtroom, Your Honor.
Okay,
We can go to position number 19 and 20.
all right. Will the host please remove Navon McGee from the Zoom? She appears to be driving. Thank you. Please remove Navon McGee. Thank you. And that was position 19 on the regular calendar?
Yes, 19 and 20.
Okay, thank you. My goodness, so many pages. Oh, there we go. This is State versus Kwame Lowe. His main case in position 20 is 20 CR 4790J, in which he's accused of battery causing substantial physical harm, simple battery, and obstruction of a law enforcement officer from September 24th, 2020. Mr. Lowe also has a bench warrant, 24 FTA 445 from April 26. No, that would not be correct. Yeah. Just 1 second, please. Would the host please remove Corletia Morris from the Zoom? Thank you. Please remove, thank you. As I was saying, Kwame Lowe has got a bench warrant. Was he just arrested yesterday on the bench warrant? It doesn't make sense.
Mr. Lowe has spent the past 2 years in Rogers State Prison and was released from prison to Fulton County.
I see. It was April 26, 2023. Okay, that makes sense then. Okay, thank you. Mr. Lowe, you've been advised of your right to remain silent, and your attorney is Ms. Vigilante. I understand this is going to be a negotiated plea. Would that be correct?
Yes, Judge, I did want to ask, I don't know if this makes the plea non-negotiated, just because Mr. Lowe is coming directly from prison, and does not have a support system. He's going to be figuring out housing, phone, probation, parole, kind of all at once. If you'd be willing to
I'm sorry, how long has he been in prison?
years,
I'm sorry?
2 years,
2 years. And how old is he?
27, turning
Yeah.
20. Okay.
Okay. And what is he trying to figure out?
Housing, he needs to get a phone. He has lost contact with his mother. He will be on parole and figuring out this probation. So just if you'd be willing to waive, maybe several months of his, probation fees to give him a chance to kind of get things together before he has to start, really hitting the ground running with probation.
This doesn't make it non-negotiated, but I'll think about it while we go through the plea hearing, and then you can allocate that again.
Oh,
All right.
thank you, Judge.
Mr. Lowe, for purposes of the plea, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Falk?
Yes, Your Honor. On Mr. Lowe's case, the state's recommendation on the battery physical harm is 12 months probation, serve 38 days, credit for time served 19 days. That's going to be from September 24th to October 3rd of 2020, and then from April 17th of 2024 until today. No further contact with Taylor Wolf, 40 hours of community service, 8 weeks of anger management courses, and no firearms. Count 2 will merge with count 1, and count 3 is 38 days, credit for time served 19 days. So we are doing that as a time served plea on the third count. The state would ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea. And we would like to sound for Ms. Taylor Wolf.
All right. Ms. Vigiletti, do you so stipulate?
Yes, Judge.
All right. Mr. Lowe, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And is anyone forcing or inducing you to plead guilty today just to get out of jail?
No, ma'am.
If you decide to enter into this plea, you would have to give up your constitutional right to a trial for this case. You will not be able to go back to court with your attorney, confront your accuser, challenge the evidence brought against you, and have the state try to carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to battery causing substantial physical harm?
Guilty.
And how do you plead to obstruction of a law enforcement officer?
Guilty.
The simple battery charge will merge into count 1. On the battery charge, the sentence is 12 months, serve 38 days, credit for time served 19 days. Once you are released, and will he have any other holds, Ms. Vigiletti?
Not that I'm aware of, Judge.
Okay. Then you will report to probation on Monday, which is next week, Monday, before 3 p.m. The probation office is at 132 Mitchell Street in downtown Atlanta. While you're on probation, you will complete 40 hours of voluntary community service, and that must be done at any nonprofit agency that's not a church and not a school. You must begin with at least 5 hours in the first 30 days and complete a minimum of 5 hours every month thereafter. You will complete an 8-week anger management program, and you shall begin that program within 120 days from today. I'm going to give you 120 days to get back on your feet, to find a job, get yourself settled, figure out how to get a phone and so forth. I'm going to waive your probation fees for the 120 days. So you have the next 4 months to get back on your feet. But every month you'll have to report to probation, do your community service, and start shopping around for your anger management classes. At all times, you're to have no contact with Taylor Wolf. You're to stay 200 yards away from this individual and not communicate with this person in any way, form, or manner. With regards to the obstruction charge, your sentence is 38 days, credit for time served 19 days. That was time served. So currently, you're only serving a sentence for the battery causing harm offense. All right. And the bench warrant is null pros.
Thank you, Your Honor. Okay, okay, well, don't leave, okay?
Next, can we go to position number 21?
Okay. Ms. McLeod wanted to speak to a Mr. Young. Is she
Yeah,
already?
she's currently on the phone with him right now.
Thank you. 21. Was that correct? Mr. Lucas? Okay. Daryl Malik Lucas is accused of battery, family violence from April 11, 2024 in case number 24 CR 1837F. Mr. Lucas, you've been advised of your right to remain silent and your attorney is Ms. Vigiletti. May I place you on the oath for purposes of the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Falk?
Yes, Your Honor. On Mr. Lucas's case, position 21, the state's recommendation is 12 months served 30 days, credit for time served 15 days, balance probated, family violence intervention program, no further violent contact with Jabaria Kwashi, 40 hours of community service, MHET, and no firearms. We did have an opportunity to speak with Ms. Kwashi. She did agree with the plea offer. She also stated that she is not in fear of the defendant and does want to have contact. My understanding is she will be here on Zoom today. So at this point, I would like to sound for Ms. Jabaria Kwashi. And we would also ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea.
So stipulated, Your Honor.
Do you see her on Zoom?
I
Ms.
do not. Ms. Kwashi, if you are here, please turn on your camera if you would like to speak. It does not appear she's here today.
All right. Ms. Vigiletti, presently it is no contact with Jabaria Kwashi. I'm sorry, it's no further violent contact with Ms. Kwashi. Do you stipulate to the factual basis, venue, and ID?
We do for the purposes of the plea.
All right. Mr. Lucas, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, I have.
Are you satisfied with your legal services?
Yes, I am, ma'am.
And are you entering this plea freely, willingly, and knowingly?
Yes, ma'am.
If you decide to enter such a plea, you would have to give up your constitutional right to a trial in front of a judge or a jury. You and your attorney will not have the opportunity to go back to court. You will not be able to confront your accuser, challenge the evidence brought against you, present any defenses or arguments you may have, and have the state prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
You understand that you will have a battery family violence conviction on your record. And if you ever get arrested again for a similar offense, it will be a felony charge,
Yes, ma'am.
right? How do you plead to battery family violence involving Jabaria Kwashi?
Guilty.
His sentence is 12 months to serve 30 days, credit for time served 15 days. If you have no other holds, you'll be released within 24 hours. You're to report to Fulton County Probation on Monday. Today is Thursday, so you'll be reporting next week on Monday before 3 p.m. at 132 Mitchell Street in downtown Atlanta. While you're on probation, you will enroll and complete a domestic violence intervention program, and you must enroll in this program within 30 days of being released. And you will continue to attend all the classes diligently until you obtain your certificate of completion. You're also to complete 40 hours of voluntary community service at any nonprofit agency that's not a church and a school. You must begin with at least 5 hours within the first 30 days and complete 5 hours every month thereafter. You're also required to do a mental health evaluation and submit yourself to any treatment that's required. You will seek out your mental health evaluation within 30 days of being released, and if treatment is recommended, you shall submit to that treatment at your expense. At all times, you are to have no violent contact with Ms. Jabaria Kwashi. You're not to engage in any physical or verbal altercations with her that may involve the police. If you do, you will risk your probation being revoked and finish off the rest of the year in prison. And also at all times, you're not to be in possession of any firearms. Thank you.
May I ask very briefly, Jabria and Mr. Lucas, I think, have wisely decided not to live together anymore. So Mr. Lucas will be looking for new housing and a new job when he's released. Is it possible to assist him with the first couple months of probation fees while he's making these adjustments?
I will waive probation fees for the months of May and June. He will start paying probation fees from July 1st. I understand that he shares a child or children with Ms. Jaberia, so they can do not third party. They can communicate to allow for co-parenting if they choose to do so.
Understood. Thank you, Your
And
Honor.
that needs to be included because the bond order required him to legitimate.
Okay. Okay. Thank you, Your Honor.
Thank you.
Good morning, Judge Law.
Morning, Deputy Milton. Yes, ma'am. How are you?
Good. I have Miss Destiny Escobar, position 6 and 7, I believe, or 7 and 8. One of the two, out of the three.
All right. This is position 7 and 8 on the SAP calendar. Ms. Escobar, Ms. Ezobu, you have a right to remain silent. Anything you say about the facts of the case, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Michael McLean. Mr. McLean is in courtroom 2. Do you see him, Ms. Ezobu?
Yes, ma'am.
All right. Mr. McLean, good morning, sir.
Morning.
This is going to be a negotiated plea.
I believe that's correct.
All right. Ms. Ezobu, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Falk?
Yes, Your Honor. The state's recommendation for Ms. Esobu is 12 months, serve 102 days, credit for time served 51 days. That's going to be from August 23rd of 2022 to August 27th of 2022. And then from March 11th of 2024 until today, balance probated. We are requesting no further violent contact with Julie Ross Hall, MHET, no firearms, and the Family Violence Intervention Program. We did speak with Miss Julie Ross Hall, and she stated that she is concerned for the safety of Miss Esobu while she's in the jail. And so we are asking for this negotiated plea. We also would like to sound for Miss Julie Ross, who I can see is here on the camera. And we would ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. Ms. Ross, if you would like to speak, please unmute yourself, and please keep in mind, do not discuss any sensitive matters, especially pertaining to any MH issues. Do you understand? Okay, great.
Mr. McLean, do you so stipulate?
We do.
All right. Ms. Ezobu, the sentence would require her to be on probation and to have no violent contact. Are you planning to have her live with you?
Ma'am, she's welcome to live with me. I'm open for her to live with me, and so she can get herself together and have somewhere safe to be. I mean, I'm at work right now in my car, and she's welcome to my home. That's my daughter. She's welcome to my home so she can get herself together. That's
all right. Okay. Ms. Esobu.
Yes.
Have you consumed any medicine or alcohol recently?
No, ma'am.
Have you understood what's been going on in your case?
Yes, ma'am, I have.
And are you satisfied with your legal services?
Yes, ma'am.
If you decide, has your attorney explained to you that if you decide to plead guilty to simple battery family violence, that you will have to give up your right to go back to court and have a trial in this case? You will not get the opportunity to have the assistance of counsel, to go back to court and confront your accuser, challenge the evidence that would have been brought against you, present your own defenses and arguments, and have the state prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to one count of simple battery family violence?
Guilty.
Your sentence is going to be 12 months to serve 102 days, credit for time served 51 days. Your jail time is concluded and you'll be released within 24 hours. If you plan to live with Miss Julie Ross Hall, you must make sure that you do not have any physical or verbal arguments and altercations with her.
Okay.
Because if you do and the police get involved, you'll be back in jail to serve out the rest of the time. Do you understand?
Yes.
While you are, you will report to the probation office on Monday. Today is Thursday. So you have a weekend to rest, and then on Monday you have to report to probation. You must report to 132 Mitchell Street in downtown Atlanta. And you must be at that office before 3 p.m. Okay. While you're on probation, you will complete a domestic violence intervention program. That's a 24-week counseling program, and you must enroll in those classes within 30 days of being released.
Okay.
Within 30 days of being released, you must also go to a healthcare provider and have an MH evaluation. And if the mental health evaluator says that you must submit yourself to any treatment, you shall submit yourself to that treatment. Do you understand?
Yes.
At all times, there cannot be any firearms on your person, in your home, in any vehicle you occupy, or anywhere near you.
Yes, ma'am.
All right. All right, Ms. Ross Hall, did you have any questions about that sentence?
No, ma'am. I just hope she does the right thing.
All right. That concludes the case. Mr. McLean, that concludes the case, correct?
Yes. Yes,
All
it
right.
does.
Thank you. All right. Thank you, Deputy Milton. All right. Courtroom 2, is Mr. Young ready for Ms. McLeod?
Yes, he's ready.
Your Honor,
Yes, Ms. Cloud?
I have spoken with Mr. Young, and this is going to be a negotiated plea.
All right, thank you. This is State versus Damari Lee Young. He's got a case under 23 CR 234E, accused of battery, family violence, from June 30th, 2022. And Mr. Young has a bench warrant from September 22nd, 2023, under 24 FTA 453. Mr. Young, you've been advised of your right to remain silent, and your attorney is Ms. McLeod. For purposes of the plea, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? You need to speak up so we can hear you.
Yes.
Ms. Falk, what is the recommendation for Mr. Young?
Yes, Your Honor. For this case, the recommendation is 12 months served, 20 days, credit for time served 10 days. That's from April 16th of 2024 into today. No further violent contact, with Jemiah Coles, 40 hours of community service, family violence intervention program, as well as no firearms. We did have an opportunity to speak with Ms. Coles, and she is in agreement with this plea recommendation. I will state that one of the reasons for the recommendation, which is slightly less than we normally offer for a first-time family violence battery, is the fact that these individuals are cross defendants. That's all for the state. We would like to sound for Ms. Jemiah Coles, and we do ask the defense to stipulate to venue factual basis and identification for the purposes of this plea.
We so stipulate, and the state is right. My client did tell me that this was a situation where both parties were cited for a situation that occurred between them. My understanding is that the alleged victim and the cross-defendant now lives in the state of California, and they have not been having any contact in recent times. My client is the custodial parent of a child which is not shared, a 3-year-old, which is not shared with the alleged cross-defendant. And he tells me that he just wants to get out so he can get back to taking care of his daughter.
Mr. Young, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your legal services?
Yes, ma'am.
Are you entering this plea offer with an honest acknowledgement that you are guilty of this offense? Or are you simply doing it to get out of jail?
No, ma'am. Yes, ma'am. I understand everything.
All right. I think you're trying to say you honestly acknowledge that you are guilty of this offense. Is that what
Yes.
you're trying to say?
Yes, ma'am.
And if you just, has it been explained to you that if you decide to plead guilty, that this will go on your record? And if you ever get arrested again for a similar offense, it may be a felony charge.
Yes, ma'am.
Are you still willing to move forward freely, willingly, and knowingly?
Yes, ma'am.
Are you prepared to give up your right to a trial, to confront your accuser, to challenge the evidence brought before you, and have the state try to prove the charge against you beyond a reasonable doubt?
Yes, ma'am.
How do you plead to one count of battery, family violence?
Guilty.
Your sentence is 12 months to serve 20 days, credit for time served 10 days. If you have no other holds, you shall be released within 24 hours. You report to probation on Monday at 132 Mitchell Street in downtown Atlanta. While you're on probation, you will complete 40 hours of voluntary community service at any nonprofit agency, beginning with a minimum of 5 hours in the first 30 days and 5 hours every month thereafter. You'll also enroll in a domestic violence program, and you may enroll in that program within 60 days. I'm going to give you 2 months to shop around and enroll in this program. At all times, you're to have no violent contact with Jamela Coles, and you're not to be in possession of any firearms.
Yes, ma'am.
Yes, Ms. McLeod?
We would ask that probation be terminated once he completes the requirements.
I can put it on non-reporting.
Thank you, Your Honor.
If he completes the domestic violence classes, which is 24 weeks long, and the 40 hours of community service, his probation will be non-reporting. So the sooner he's done with that, the more money he'll save.
Thank you, Your Honor.
All right, thank you.
Your Honor, that concludes my business before the court today. May I be excused?
Yes, have a good day. Thank you.
You too.
All right, courtroom 2.
Yeah. I haven't seen it for a while. Are you ready? We can go to position number 5, Mr. William Chapman.
All right. Thank you. Mr. McLean, how are we proceeding with Mr. Chapman?
Your Honor, it's a negotiated plea. The defense is in the process. We've begun, but it was too early in the morning for them to accomplish this task. We've begun the process of contacting Cobb County Jail to be able to prove that this case was a hold on him in the Cobb County Jail from March 18th forward. Therefore, he would be entitled to an additional 14 days of jail credit. And instead of 15 extra days starting today, he would actually have 1 extra day. But we do need to prove that to the court, and I hope to fire off an email to the Cobb County, what they call R&I, Records and ID.
So are you still holding for a response from Cobb County for confirmation that he should be given credit for 29 days?
Yes, Your Honor. Perhaps we could put it in the form of, if the defense is able to prove what I anticipate we can prove, that the record room would be instructed to do A or B.
Ms. Falk, do you have any information one way or another if Mr. Chapman has been incarcerated for 14 days in Cobb County?
I don't. This is the first time I'm hearing of this, so I don't have any information.
Right. And the principle is, Your Honor, of course, in Cobb County, whatever he had, if this case was a hold, it wouldn't matter if it was one of 100 matters, it would have prevented his freedom had everything else been cleared.
All right, so we are going to curate a McLean special. In other words, the sentence would be that the sentence would be 12 months to serve 60 days, credit for time served 29 days. Only and only if Mr. McLean provides proof to the clerk's office that he has been in custody for an additional 14 days. Otherwise, the alternative sentence of 60 days, credit for 15 days will kick in. Is that the McLean special this morning?
That would be, Your Honor. I'm gonna get that whether it takes me going to Cobb myself or not. I haven't been to Cobb in a while.
That's quite all right. They have some pretty good restaurants and cafes. Ms. Falk, do you have any objection to this?
I do not, Your Honor.
All right. Okay, Mr. Chapman, my name is Judge Law, and you've been accused of battery, family violence from case 24 CR 1834Y. With regards to this case, you've been advised of your right to remain special, and your attorney is Mr. Michael McLean. May I place you under oath for purposes of this plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Chapman, you understand, you may put your hand down. You understand that if I accept this plea offer, one or two things will happen. Either you will only need to spend one extra day at jail and then report to probation, or you would need to spend an additional 15, no, let me see. It will be 15 more days. Do you understand?
Yes, ma'am.
That is subject to us confirming whether you spent any time at the Cobb County Jail. Are you willing to move forward with this plea, or I can reset it to next Tuesday?
We can move forward with it, Judge. I have a way of also contacting to have them to send something.
No. Don't deprive Mr. McLean of his field trip to Cobb County. I would not even think about that. Okay. All right, Ms. Chapman, Ms. Falk, other than the time that he has to serve, what other requirements is he required once he's on probation?
Family Violence Intervention Program, 60 hours of community service, no further contact with Quahita Park, stay away from 705 University Avenue, no firearms. We would like to sound for Ms. Quahita Park, and we do ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea.
For said purposes, we do so stipulate.
Ms. Park? All right. Mr. Chapman, have you consumed any medicine or alcohol?
No, ma'am.
And have you understood the proceedings so far?
Yes, Judge.
Are you satisfied with your attorney?
Yes.
And are you entering this plea freely, willingly, and knowingly?
Yes, I am.
If you decide to plead guilty to this offense, it will go on your record, and any subsequent arrests may be a felony charge for a similar offense. Are you still willing to move forward?
Yes, I am.
If you decide to plead guilty, you would be giving up your right to a trial in front of a judge or a jury. You will not have the opportunity to confront your accuser, challenge the evidence brought against you, present any defenses or arguments if you choose to do so, and have the state prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, I am.
How do you plead to one count of battery, family violence?
Guilty, y'all.
Your sentence is 12 months to serve 60 days. You may end up serving an additional 15 days if there's no confirmation of your time in Cobb County, or you may end up serving an additional 1 day if there is confirmation that you served an additional 14 days at Cobb County. So either be credit for 29 days upon confirmation, or credit for 15 days if there's no confirmation. Oh, Miss Grace, I'm so sorry. I have to apologize because Miss Grace is recording all this for me. In either event, once you are released from the Fulton County Jail, you will report to probation on the first available business day, which will be a Monday, a Tuesday, or a Thursday. The probation office is at 132 Mitchell Street in downtown Atlanta. While on probation, you will complete a domestic violence intervention program, and you have to enroll in that program within 60 days of being released. Do you understand, sir?
Yes, ma'am.
And you must attend those classes every week. You're also to complete 60 hours of voluntary community service at any nonprofit agency, beginning with 5 hours in the first 30 days and a minimum of 5 hours every month thereafter. You're to have no contact with Quahita Park. You're to stay 200 yards away from Miss Park and not communicate with her in any way. You're also to stay away from 705 University Avenue in Atlanta, Georgia. At all times, you're not allowed to possess any weapons or firearms. Do you understand, sir?
Yes, ma'am.
All right. That concludes the sentence. Thank you.
Get it done, or get it done, or amend it. You sure?
Mr. McLean?
I've got a question.
Yes, sir.
Number 30, I'm looking at my copy of the recommendation, and I think there's a blank number. I think there's a typo.
Who are we talking about? Darian Williams or Kayla Williams?
Kayla Williams, 30.
All right. It looks like
There is indeed. The calculation of the credit for the time served, I believe the credit for the time served would be 12 days.
I think
P.D. McLean.
I think that's right.
Right, because it would have been 10 days and then 2 more days from 9/28 to 9/29. So it's a time served. Well, I mean, it's time served plus probation.
Sure. Thank you.
okay. Who's next in courtroom 2?
Your Honor, the rest of quorum 2 is Ms. Vigilantes, and she's currently talking to one of the clients.
Miss Vigilante, is she available now?
She's currently talking to one of her clients.
Okay. Mr. McLean, do you have any matters to address?
Your Honor, I'll note that there's going to be a waiver, I believe, on Sappho Davis Sappho. I think his
Yes,
name.
that's the add-on, isn't it?
Yes, Your Honor. I believe they switched his names around, first name, last name.
Okay, Sappho Davis or Davis Sappho, that's an add-on on our calendar.
Right.
And it would be a waiver of presence or waiver of arraignment.
Both.
All right. And please,
I'll sign that on his behalf. When he started telling me his siblings' names all ended in Sappho, I figured that out.
okay. So Sappho Davis or Davis Sappho, that's going to be a waiver of arraignment, further notice for trial. And then on position 4 and 5 on your add-on, on my add-on calendar, and Anthronica Troutman has been released.
Correct. I believe that is correct. When I went to the ACDC, they said that she was released from them. And the only reason that she would be released from ACDC would be really to come to Rice Street to be released from here.
All right. Would Miss Vigilante be able to take a pause and address the next cases? I'll take a recess at 10 o'clock for her to continue our conversations.
Yes, we can go to position number 9. Mr. Antoine Copeland.
I'm sorry, Miss Vigilante. I'll take a recess at 10 a.m. And then if you want to continue your conversation with your clients in there. It's just going to be a brief 10-minute recess. All right.
We can do position number 26.
26, okay.
Timothy Rutledge. Right here, right here. On the bridge.
Okay. And Miss Vigilante, this is going to be a plea?
In part, Judge, Mr. Rutledge has 2 cases open. He is position 2 on the add-on calendar. He's also position 26 on the SAP calendar. I believe it is the add-on calendar case that he's been in custody on for 121 days, and the offer is time served. I also believe that is the case that's holding him. So Mr. Rutledge would like to take a plea on the add-on case number 24 CR 002159J this morning, and plead not guilty to the case on the SAP calendar.
All right. Ms. Falk, we're going to be addressing both his cases. Do you have them before you?
Yes, Your Honor. I will say this was a global recommendation, which is why they were together in position 26. So the state is not inclined to separate these 2 cases, especially because position 26 is consecutive time to the add-on case. So I'm not inclined.
Understood. Ms. Vigiletti, your client can, he can definitely exercise his right and plead not guilty, and we can further notice both cases for trial.
Your Honor, my client has spent 121 days in the jail on this theft case. It is a misdemeanor. The
Let
other
me-
case was
let-
7 years prior.
Okay, yeah, I do see that. So let me see. I'm looking at the add-on case. Okay, first of all, Mr. Timothy Rutledge, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and Ms. Vigiletti is your counsel. You have 2 open cases with us. That would be correct. The first one is 24 CR 2159J. That's on the add-on calendar. This is an arrest in which you are charged with theft by shoplifting and terroristic threats and acts. And Mr.
Excuse me, I was told shoplifting. That's it.
Mr. Rutledge, listen very carefully. Listen very carefully. In this new case, you are charged with theft by shoplifting and terroristic threats, and you were booked into custody on January 26, 2024.
Excuse
And
me,
you have a $2,500 surety bond in that case.
my charge here too.
Alright. So that's the bond he has. On the older case, theft in which he was accused of theft by shoplifting, in case number 17 CR 8484J, this was an incident from July 3rd, 2016.
Yes, Judge.
All right. And since then, he's had other matters in which he's been arrested between July 2016 and thereafter with Fulton County. If he decides he wants to challenge one of the 2 cases, he would have to challenge both cases, and he certainly has the right to enter a not guilty plea, and we can further notice both cases for trial. He has bonds, I believe, in both cases.
Yes, Judge, he does. He does have a surety bond that he cannot afford, which is, why he's been here for 121 days. If I may speak to Mr. Rutledge briefly.
All right, go ahead and mute your calendar. Please keep in mind that I'm taking a 10-minute recess at 10 a.m. Yes, Ms. Vigiletti?
Your Honor, Mr. Rutledge would like to enter a plea to both cases this morning.
All right, he's decided to accept the global recommendation.
Yes, Your Honor.
This would require him to be on probation for up to 24 months. Would that be correct?
I believe it's 12 months when he's released from the jail. My understanding of the offer is it's time served on one case and then 12 months begins on the next case when he is released.
All right.
That is correct, Your Honor.
All right, so Mr. Rutledge has been advised of his right. Mr. Rutledge, please raise your right hand for purposes of the plea. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Falk, you can give me the recommendation for both the cases, 17 CR 8484J and 24 CR 2159J.
Yes, Your Honor. The recommendation on the add-on case, let's start with that first since it is a time served, is Time served 242 days, credit for time served 121 days. That's going to be from December 26, 2023 until today. And the second count, the terroristic threats, will be 242 days, credit for time served 121 days. I will point out that since the incident in 2016, that was around cycle 18 of this defendant's history, he has 53 total cycles. So he racked up about 45 more cycles after the 2016 incident. And that is the reason for the state's recommendation. The theft by shoplifting, the position 26 case, the recommendation is 12 months to run consecutive to the add-on case. Stay away from Walgreens, located at 4617 State Route 138 in Union City, and stay away from Murphy USA, located at 6135 Old National Highway in College Park. We are also recommending 40 hours of community service, an anti-theft course, a $500 fine, and no further contact with Nia Taylor, who is the victim of the terroristic threat. I will point out that the anti-theft course and the $500 fine are statutory based on his prior theft by shoplifting convictions. We would also like to sound from Ms. Nia Taylor, and I would ask the defense stipulate to venue, factual basis, and identification for the purposes of this plea. That's all for the state.
Ms. Taylor? Ms. Rutledge, do you, excuse me, Ms. Vigilante, do you so stipulate?
We do for the purposes of the plea.
Mr. Rutledge, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood what is the recommendation and what's been going on in your cases?
Yes, ma'am, I know. So I have a question.
Yes, sir.
Does this mean I'll be getting out today?
Yes, you'll be released within 24 hours, but you will need to report to probation on Monday.
Okay, do I have any holds?
Not that I know of, other than these two cases.
Okay, thank you.
Does he have another shoplifting case from June 30th, 2023?
He does, Your Honor.
He does, but I believe that is a
UJR. Yeah.
Well, I thought that was a felony case. I can go back and double check.
No, I'm just looking at the bond status. It's still listed as a UJR. So, all right. So he does have other open cases in addition to what might be a probation case now. All right. So, Mr. Rutledge, are you satisfied with the legal services you've received?
Yes, ma'am, I am.
If you decide to plead guilty, you would have to give up your constitutional right to a trial to challenge both these cases. You will not be able to have your attorney go back to court with you to confront your accuser, to challenge the evidence that will be brought against you, to present any defenses and arguments you may have, and to have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
If you're okay with not going to trial.
Yes, ma'am, I am.
In case 24 CR 2159J, how do you plead to one count of theft by shoplifting and one count of terroristic threats?
Guilty.
Your sentence is 242 days, credit for time served 121 days, and that concludes your sentence for both these. These are concurrent, so your sentence for this case is concluded. With regards to the older case, 17 CR 8484J, how do you plead to theft by shoplifting?
Guilty.
Your sentence is 12 months probation consecutive to the case that we just addressed. And that means you will be on probation for the next 12 months. You will report to probation, which is located at 132 Mitchell Street in downtown Atlanta, and you must report there on Monday before 3 p.m. If you fail to report, a probation warrant will issue and you will be arrested to complete 1 year in jail or 1 year in prison. While you're on probation, you are to stay away from the Walgreens at 4617 State Route 138 in Union City. You're also to stay away from the Murphy USA gas station at 6135 Old National Highway in College Park. You will also complete 40 hours of voluntary community service at any nonprofit agency that's not a church and not a school. You must begin with at least 5 hours in the first 30 days and complete a minimum of 5 hours every month thereafter. You're to undertake an anti-theft class, and you must enroll in that class within 60 days of being released. You are to pay a $500 fine, and you have the next 12 months to pay the $500 fine. $250 of that fine must be paid within the first 6 months, and the remainder of the $250 must be paid in the second half of the 6 months. At all times, you're to have no contact with Nia Taylor. If you violate any of these conditions of probation, probation is authorized to issue a warrant for your arrest so that you can complete the remainder of the 1 year in prison or in jail. That concludes your sentence.
Thank you, Your Honor.
Who's next, please? I can take one more case. Ms. Vigilante, do you need to speak to your client?
I do, yes.
All right. Ladies and gentlemen, we'll be in a 10-minute recess, and then we will resume at 10:10. Thank you very much. Just want to make sure that the host, you will manage the Zoom and make sure that nobody is talking unnecessarily. Okay? Thank you.
Yes, ma'am.
Good morning. Are we ready for position number 4, Mr. Braddock?
Medical, the judge is in a recess at the moment. She'll be back shortly.
Thank you.
Sorry about that. Took a little longer than expected, but we are back on our SAP calendar. Again, if you're a defendant on this calendar, please remember that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you would be, if you cannot afford one, one will be appointed to represent you. Medical, who do we have, please? Unmute, please.
This is position 4.
Okay. That would be Mr. McLean's client. Okay. This is State versus Marcel Braddock, accused of theft by shoplifting in case 24 CR 1663B. Mr. Braddock, you've been advised of your right to remain silent, and your attorney is Mr. Michael McLean. This is going to be a negotiated plea. May I place you under oath, Mr. Braddock? Do you raise your right hand?
Yes.
Are you Marcel Braddock?
Yes.
All right. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. You may put your hand up. Ms. Hall?
Yes.
Yes, Your Honor. The state's recommendation is 12 months, serve 46 days, credit for time served 23 days. The time will be calculated from April 3rd, 2024 to today, balance probated, $500 fine, 40 hours of community service, an anti-theft course, and stay at Walmart at 4735 Jonesboro Road in Union City. We would like to ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea. That's all for the state.
For said purposes, we do so stipulate, yes.
Mr. Braddock, have you consumed any medicine or alcohol?
No, I have not.
And have you understood what's going on in your case?
Yes.
Are you satisfied with your lawyer?
Yes.
And if you decide to plead guilty to theft by shoplifting, you would have to give up your constitutional right to a trial, to confront your accuser, to be able to challenge the evidence brought against you, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of theft by shoplifting?
Guilty.
Your sentence is 12 months to serve 46 days, credit for time served 23 days. If you have no other holds, you will be released from jail within 24 hours, but you must report to probation on Monday. Today is Thursday, so you must report on Monday before 3 p.m. at 132 Mitchell Street in downtown Atlanta. While you're on probation, you will pay a $500 fine, do 40 hours of community service in any nonprofit agency that's not a church and not a school. You must complete at least 5 hours of community service per month, beginning with the first 30 days. At all times, you have to stay away from the Walmart store at 4735 Jonesboro Road in Union City. Most likely, they have your picture in every Walmart, so I would recommend you do not enter a Walmart for a whole year. Do you understand?
Yes, ma'am.
All right. Any
Your
questions?
Your Honor, I do need to ask whether Mr. Braddock feels that he'll be able to pay the $500 fine during the course. I got one in my bank account. Or should he ask, do you think you should ask to convert that to community service, sir? Or do you think you can pay the $500? I can pay, I got the money. Okay, thank you.
All right. Mr. Braddock, on the fine, the $250 must be paid in the first 6 months and the remainder in the rest of the 6 months. You understand?
Yes, ma'am.
Thank you. All right. Next case, please.
We have to go down the hall and grab some more people.
Okay, thank you. Okay. Mr. McLean, everyone's vacated, with the exception of one person all the way back there. Do we have any cases in courtroom 2?
Stephanie, who is that? Who's in the back here?
Miss Vigiletti's client.
Oh, okay. All right.
That is position number 24.
Number 24 is the gentleman in the rear of the courtroom, Your Honor.
Are we ready to address that case?
Ms. Vigiletti is speaking with another client right now, and
Okay.
yep. That must be Mr. Richmond.
Calvin Richmond. Okay. We'll just be on hold until someone appears either in courtroom 2 or in medical. Thank you.
F.O. Davis, it would save me a minute of looking up if somebody gave me the case number 24CR00. What are the other digits?
For which case?
The add-on Sappho Davis.
Sappho Davis on the add-on calendar. I'm just having to switch windows here. Sappho add-on, that was,
It looks like it's 24CR001756D.
That saves me a minute. I appreciate it.
okay. All right, Ms. Vigiletti, position, is that position 24?
Yes.
All right,
Your Honor, this is Mr. Calvin Richmond.
yes, okay. This is State versus Calvin Richmond. We are going to waive sounding on the misdemeanor charge. This is case 24 CR 1806C. Mr. Richmond, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Vigiletti. Has Mr. Richmond been shown a copy of the charge and the accusation, Ms. Vigiletti?
I did not show him a physical copy, but we did discuss the charge and the accusation.
And how are we proceeding today?
Mr. Richmond would like to discuss the possibility of a non-negotiated plea this morning.
Okay. Go ahead. Mr. Richmond, the prosecution is going to let me know what the recommendation is, and then I'll hear from your attorney. And before I make a decision as to which recommendation I will accept, keeping in mind that I have a right to disregard either option and have the case scheduled for trial. Ms. Falk?
Yes, Your Honor. I'm also pulling up the defendant's history. So the state's recommendation on this case is 12 months served 60 days, credit for time served 15 days. That's from April 11th, 2024 to today. Balance probated, SDET, no further contact with Eden Reed, stay away from all murder stations, and 40 hours of community service. This case, which happened on April 3rd of 2024, involved Miss Reed. The two of these individuals did not know each other. She was riding on MARTA bus 5, and the defendant grabbed her upper torso.
Yeah,
I wasn't going to say the word upper torso for a total of 12 seconds.
Okay.
This defendant's history is extensive. The defendant has a total of 35 cycles beginning in 1981, just to kind of hit the highlights that have happened in the last 10 years. The defendant has aggravated assault that was reduced to a simple assault in 2020, driving without a license, a probation violation in 2022, where he was revoked and given 30 days of confinement. And this case, prior to that, the defendant had several drug charges going back to the 90s, tampering with evidence, 1 year confinement for drugs in 97, simple battery case in 97 that does not show a disposition, as well as several theft offenses and some more batteries and simple batteries in the late 90s. And so the recommendation was based on the defendant's extensive history and the acts involved in this case. We would like to sound for Ms. Eden Reed, and we do ask the defense to stipulate, if they do so choose to go forward with a plea, to venue factual basis and identification.
All right. So basically, you're asking for 15 days additional jail time, and then to be on probation to complete the program and stay away from all MARTA. All right.
That is correct.
Ms. Vigiletti, what's the defense recommendation?
Yes, Your Honor. I spoke with Calvin Richmond today. I will just begin by saying I tried to speak with him yesterday morning and evening. He wasn't able to be located because he was at Grady Hospital for an injury. And so typically this is a case where I would bring others in as witnesses to vouch for Mr. Richmond. The fact that they're not here this morning is only because I've just met him this morning. I do understand Mr. Richmond has significant criminal history, but we are asking for time served on the jail portion of this case this morning. The first thing Mr. Richmond said to me when we began the interview was that he was very apologetic for any harm or offense from this incident. He does have an extensive history, mostly related to drug use. He was homeless for 4 years until recently. But Mr. Richmond has made incredible strides in the past year. He joined an AA program. He is part of Atlanta Rapid Rehousing. He's actually supposed to move into a new apartment at the end of this month. Although he is in a temporary place now, he's moving into a long-term place. He not only attends AA at 575 Central Avenue as a Terra Club, but he also works there as a custodian. He listed a number of supports, counselors. He has a psychiatrist at 10 Park Place that he's working with. These are all very recent interventions in Mr. Richmond's life. And my fear with leaving him in jail for 15 more days is that it's a risk of disrupting the things that I do think are going to continue to put Mr. Richmond on a better path. He understands the other terms of probation. We discussed them at length. We've already devised a plan for how to complete them. He understands he cannot take MARTA, and because he doesn't drive, we've talked about having friends and supports make sure he's getting to his probation appointments and other appointments. I do believe he's motivated to get this probation done and done correctly. I am just worried about the instability that might result in longer jail time because he is right on the cusp of getting some stability.
I'm accepting the state's recommendation, given the nature of this charge, given the highly egregious allegation against another member of the community for no rhyme or reason. If he's acknowledging this crime, this is right at the border of being a felony matter if it had gone any further. So if he wants to accept the additional 15 days in jail, then he'll need to be on probation. Otherwise, we can further notice this case for trial.
Understood, Judge. If we may just speak briefly. Your Honor, Mr. Richmond would like to enter the plea this morning. And we do stipulate to venue basis and factual basis when I need.
All right. Mr. Richmond, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Have you consumed any medicine or alcohol recently?
No.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your legal services?
Yes, ma'am.
And is anyone forcing you or inducing you to take this plea offer today?
No.
If you decide to accept this plea offer, you would have to give up your constitutional right to a trial. You will not be able to go back to a court of law with your attorney to confront your accuser, challenge the evidence brought against you, to be able to present any defenses and arguments, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to the misdemeanor offense brought against you?
I plead guilty, ma'am.
Repeat.
Guilty.
I accept your guilty plea. Your sentence is going to be 12 months to serve 60 days, credit for time served 15 days. You have an additional 15 more days to serve at the Fulton County Jail, after which you will then report to probation, which is located at 132 Mitchell Street in downtown Atlanta. While you're on probation, you will complete a program that we refer to as an SDET, and you must enroll in that program within the first 120 days of being released. You are to have no contact with Eden Reed. You are banned from all MARTA services while you are on probation, which includes buses and trains. You're also to complete 40 hours of community service at any nonprofit agency that's not a church and not a school. You must begin your community service with at least 5 hours in the first 30 days and complete a minimum of 5 hours every month thereafter. Do you understand, sir?
Yes, ma'am, thank you.
Medical, who do we have, please?
We have add-on position number 1, Mr. Davis.
That's the waiver.
All right. This is State versus Mr. Sappho Davis or Mr. Davis Sappho. Mr. Davis or Mr. Sappho, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Michael McLean. Do you see your attorney on the screen?
No, ma'am.
All right, Mr.
Oh, yes, I do.
All right. This is 24 CR 1756D, in which the defendant is accused of simple assault from April 6, 2024. Mr. McLean, are you planning to file a waiver of arraignment?
Yes, Mr. Sappho, do we still plan to just waive this presence and plead not guilty? Is that correct?
Mr. Sappho, Mr. Davis, do you hear your attorney?
Do I hear him?
Yes,
Yeah,
he's asking you a question. Can you respond, please?
What did he just say?
What I was saying was, you and I discussed doing a waiver today, and it's my understanding you wanted to just waive your presence and plead not guilty. Is that correct?
I'm looking at you right now. I waive my presence.
You are right now, but is that wrong?
Right, sir?
All right.
Yeah, I'm looking at you.
Mr. Sappho Davis, thank you for being here. Your attorney indicates that you want to enter a not guilty plea and have a trial. Would that be correct?
Yes, ma'am.
All right. Mr. McLean, would you like to go ahead and file the waiver of arraignment?
Yes, Your Honor, it's filled out. We'll file it. The copier machine scanner in the next room is not working today, so.
All right, we'll wait for you towards the later of the day. Mr. Sappho Davis or Davis Sappho, your case will be reset for trial. Thank you.
Yes, ma'am.
Position number 9.
Number 9.
Your Honor, position number 11, he refused.
Number 32 and 33.
All
And
right.
position number 32 and 33 refused.
Position 11 and
32 and 33.
Abraham Harris. Ms. Vigiletti or Mr. McLean, have you spoken to Mr. Abraham Harris or attempted to?
Judge, I've attempted to every time he refuses to come to the interview booth, says he is pro se. Actually says he's power of attorney, but I think he means pro se. I have not met him, even though I have tried to go see him multiple times.
All right. We will reset him to next Thursday, which would be May 2nd, I think.
Yes, Your Honor.
Unless the jail has a process in which to bring Mr. Harris to the screen in a seated position. Deputy?
I mean, we'll try, but he's he's a piece of work. He's a little project.
All right.
Your Honor.
Yes, Ms. Falk?
My apologies. I was not intending to interrupt. I would just say when we've had this issue come up before, one of the things that has been done, I'm not sure if medical can do this, but they have done it before, is to take a cell phone to the cell door so that Your Honor can communicate with the defendant and the defendant can communicate with Your Honor. My concern is he's been in custody for 35 days and there hasn't been any contact, and I am concerned about that.
All right. Officer Norris, is it Officer Norris there? I'm sorry, you're so tall, you don't even come to the screen. Can you use your jail card? Can you use your jail court iPhone to address Mr. Harris? And
that's we can try that.
okay.
He's kind of
Yeah.
competitive.
And we can also do it for position 32 and 33.
I believe he's kind of combative, Your Honor. So,
Oh, I know that wouldn't be the first time for us, but it will be for Ola Juwan Wilson and for Abraham Harris. If somehow or another we can get him on screen, whether it's a jail court iPhone, just to make sure that he has a one-on-one with a judicial officer who can explain his rights, and let's see what he wants to do.
All right. Well, Abraham Wilson, Abraham Harris, he's he's a little difficult. The other guys just won't say anything, but Abraham Harris, he's the one that's combative.
Officer Gopi, would you like me to come with you and I can try to explain to him, we're trying to get him out of the jail today?
We're trying to get him out of the jail cell. Let's make it one thing straight. We're trying to get him out of his jail cell to talk to us. So either way, Miss Deputy, you make the call whether you want to do it jail court iPhone or any other procedures that the sheriff's office has.
Okay, yep. We'll come down. I'll come down and we'll talk about it.
All right, thank you.
Okay.
Good morning, Your Honor. I'm sorry.
Good morning. Deputy Milton, I will go to AC and DC. I will go to ACDC as soon as I address the case in courtroom 2.
Thank you.
All right. Courtroom, Ms. Vigiletti, who do you have seated next to you?
this is position number 9, Mr. Antoine Goodwin.
Mr. Antoine Goodwin is accused of misdemeanor terroristic threats and acts and willful obstruction of an officer from March 24th and March 25th, 2024. Case number is 24 CR 1846G. Mr. Goodwin, you've been advised of your right to remain silent, and your attorney is Ms. Vigiletti. Ms. Vigiletti, after your interview, how are you proceeding with this case, or how is he proceeding?
Yes, Judge, Mr. Goodwin would like to discuss the possibility of a non-negotiated plea, simply because he does have 2 other holds that he's eager to be released to.
All right. We will have a non-negotiated plea hearing, and Mr. Goodwin, I will hear from the prosecution, then I will hear from your attorney. I will let you know what my decision is before you decide whether you want to move forward with the plea. Ms. Falk?
Okay. So on this case, Your Honor, the state's recommendation is 12 months on the terroristic threats with 60 days to serve, credit for time served 16 days. That's going to be from April 11th, 2024 to today. No further contact with Shamika Boatman. Stay away from 2210 Sullivan Road in Atlanta, Georgia. On count 2, which is the obstruction of an officer, the state's recommendation is 12 months to run concurrent with count 1, as well as a $300 fine. I will state that we had an opportunity to speak with Ms. Shamika Boatman. I would like to sound for her at the conclusion of this, and I would like to say that she does agree with the terms of the plea. Mr. Goodwin's history consists of 38 cycles. That's going all the way back to 1996. The defendant is a convicted felon. In 97, he had a criminal trespass, family violence, battery that he pled guilty to. 98, burglary. 90, let's see.
Anything more?
Oh, yes. Your Honor. I just am also trying to give Your Honor a little bit of his
Understood. Well,
history.
the 38 cycles is telling, but any
Right.
convictions recently?
Yes, let me move up to his last 10 years. So starting with, let's see. Sorry, I'm still going through. Okay, there we go. Starting with an entering auto in 2013, to which he pled guilty, theft by shoplifting, which was then dismissed. Let's see, theft by shoplifting and 2 counts of theft by shoplifting and theft by taking in 2014, which he was found guilty of, a parole violation in 2016, another theft by shoplifting and parole violation in 2016, where he was given 2 years confinement, another parole violation in 2017, criminal trespass in 2019, for which he was given 60 days confinement, credit for time served 41, probation violation where he was, it looks like, revoked and restored to probation in 2019, another 2019 probation violation, a 2020 family violence battery for which he was found convicted. He was convicted in 2020 and given 30 days confinement, and that included a probation violation. A criminal damage to property in the 2nd degree for which he was found guilty in 2021. He received 5 years probation on that case, and it ran consecutive with some other sentences. And then this terroristic threats and acts case. Your Honor, in this case, the defendant sent Miss Shamika Boatman a number of threatening messages via text message saying he was going to destroy her. Emma effed you up, just know. He also told her he was going to damage her vehicles that she owns. He then showed up at her apartment on March 25th and began banging on her door after sending her these messages. And so based on his extensive history, we would state that the 60 days confinement is actually a little generous. So we would ask that that plea remain as set. And we would ask that if the defense does agree to go forward with the plea, that they stipulate to venue, factual basis, and identification for the purposes of this plea. At this time, we would like to sound for Shamika Boatman.
Ms. Shamika Boatman, if you'd like to address the court, may I place you under oath?
Yes.
The other right hand.
Yes. I'm sorry. I'm so
You
sorry.
solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Do you have any concerns if Mr. Boatman is released on probation?
Mr. Goodwin?
Mr. Goodwin, excuse me.
I mean, I do. I mean, when all this situation happened, I stay in an apartment complex and he was sending me all kind of messages and saying that he was out there and he was seeing me when I didn't see him. So it was kind of like when I get ready to go to work and stuff like that, you would be like, yeah, I see you. And, you know where I park my cars, you know how I was parked. Like, so I was pretty nervous. And then plus other things that happened since this situation too, that I was thinking that he was also getting arrested for. So that's what the police was telling me. Because I was working for a Fulton County police officer. He stole my gun out of my house, which caused me to lose my job. That gun is also reported stolen with the College Park Police Department. So I don't know if all of this is going in with this situation or something different. I have recordings of him saying that he took the gun from me, but saying that somebody else stole it from him. So it's just been it's been stuff on top of stuff.
All right. Thank you, Ms. Boatman.
Thank you.
Ms. Vigiletti, what's the defense recommendation?
Yes, Judge. What we're requesting today is that Mr. Goodwin be released to his hold. We're not suggesting any other alterations of the state's recommendation. I do absolutely understand what Ms. Boatman is saying, as well as Ms. Bach. Mr. Goodwin will not be, if he's being released to his hold, it's not likely he will be released soon. He tells me that one hold is criminal damage to property and one hold is a probation violation. So it doesn't impact, whether or not Mr. Goodwin will be free or whether, Ms. Boatman will have to worry anytime soon about Mr. Goodwin being out.
So once, if I go with the state's recommendation, he is going to serve an additional 9 days at the jail. And then he's going to be, well, I'm sorry?
It will be 16 additional days, I believe. right? Because it's credit for time served 14 days.
Oh, yeah, you're right, 16, yeah. I don't know why I didn't carry over one. Okay, yeah, it's 16 additional days, and then after that, he will not be released to probation. He has to report to the DeKalb County or Bibb, not report, but either DeKalb or Bibb County would have to come pick him up
That's right.
to address that. And then once he's done with those matters, then he'll need to come back and start his probation.
Yes,
So
Your Honor.
what in this process is the defense seeking to amend?
Just the jail.
Put your arms down. Put your arms down.
Mr.
And put mask up. Thank you.
Would just like an opportunity to get started on resolving his DeKalb and Bibb County charges. So he'll still be in.
I'm not stopping him from that. I'm asking, what is it about this sentence then? After he's done with this holds, he needs to come back to Fulton County and start his conditions on probation.
Yes, Your Honor.
So what is the non-negotiated part?
Just the jail sentence, just the jail portion, if it could be converted to serving 28 days so he can be released to the holds.
Denied.
Understood, Your Honor.
Okay, so would he like to have a trial, or would he like to proceed with his plea? Because right now, he's got a $1,000 surety bond on the terroristic threats with a release to the hold. So which way would he like to go?
If I could just have 1 second, Your Honor.
Jail court iPhone, who do we have in that room?
This is, I'm sorry, this is add-on number 2, Mr. Slayton.
Add-on number 2. Okay, I believe that that's going to be Mr. McLean's client, and we will get to you very, very shortly. Is that Timothy Rutledge?
I'm sorry.
Is that Timothy Rutledge?
No. This is,
Add-on number 2.
yes, Antoine Slayton, add-on number 2.
Okay, I've got him as number 3, but don't worry about it. Okay, that's going to be Miss Vigiletti's client. And as soon as we're done with this one, we will address that.
Okay.
Any luck with the other 2 cases so far? I know I'm asking too soon.
Is that the 3 North, the guys from 3 North?
Yeah, the ones who refuse to come out.
Oh, no, not yet. We're gonna come up here and address these cases and go back
Okay,
down.
understood. Thank you. All right, Miss Vigiletti, shall we proceed? All right, ACDC, while we are waiting for Miss Vigiletti to complete her consult. Fulton ACDC. Oh, sorry about that, Deputy Milton.
Good morning, Your Honor.
Deputy Milton, I need to get you that remote control for the Zoom. Okay.
Okay.
Listen, first of all, let me advise the ladies of their rights. Yes, good morning, ladies. My name is Judge Lal, and we're going to be addressing each of your cases on a one-on-one. Please remember that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and if you cannot afford one, one will be appointed to represent you. Which cases do we have at ACDC?
Position 14 and 15, Jenna Hoyt.
Okay, and what are the... No, I'm not addressing them yet. I just need to know who's there.
Okay, position 16, Miss, but I'm sorry, I'm gonna get him last.
Okay, and then go ahead.
Position 30 and 31, Kayla Williams.
Okay.
34 and 35, Tierica Wingfield.
Okay.
And Brittany Morris, I don't have a position number for her. I did not see one.
What's that name again?
Morris is the last name. Brittany is the first name.
Do you have a case number? Or
She's on
building
the, she's on the probation calendar, Your
Oh,
Honor.
I see. Okay.
Position 5 and 6.
Yeah, that's the only one we're waiting on. Okay, is Mr. McLean representing Brittany Morris?
Ms. Morris? Come on now.
Yes, Your Honor, that's Mr. McLean's client.
Okay. Brittany Morris, if you please come and take the seat, thank you. And then the other one, other probationer we have is Ronnie Smith. Miss Brittany Morris, you have a probation revocation matter. You've been advised of your rights and your attorney is Michael McLean. Your original case is 22 CR 242Y, in which you were convicted of disorderly conduct and or simple battery. And you've got a probation revocation matter with regards to that disposition. Officer Barnes? Probation Officer Barnes? Let me see. Ms. Thomas with probation, do we have anyone available to address this?
I'm getting ready to, let me call over there because he was just on. Let me just call over.
No, I'm sorry.
No, you're fine.
Mr. McLean, what is your understanding with regards to this, to the state's recommendation while we're waiting for probation to appear?
Continue on probation, Your Honor.
To continue on probation? Okay.
Correct.
Mr. McLean, the gentleman at Jail Court iPhone is on the add-on calendar. Is that your client? No, that's Miss Vigiletti's client. Okay.
Right.
Okay.
She is ready, Your Honor.
I know. All right, we're still waiting on Officer Barnes. ACDC, please hold. Miss Vigiletti, how would your client like to move forward for Mr. Richmond?
Mr. Ritz, I would like to enter. I'm sorry, Mr. Goodman would like to enter the plea today.
Mr. Goodman, I beg your pardon, sorry.
Okay, well, come sit with us.
All right, Antoine Goodwin, please raise your right hand for purposes of the plea. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Okay, and Ms. Vigiletti, do you stipulate to the factual basis, venue, and ID?
We do for the purposes of the plea.
All right. Mr. Goodwin, have you consumed any medicine or alcohol recently?
No.
And have you understood the proceedings so far?
Yes.
You understand that your probation will be on hold until you've resolved all your DeKalb County, Bibb County, or any other outstanding holds. Then you would have to come back to Fulton County probation to complete the conditions of your sentence.
I thought she said pay $300.
The condition is to pay a $300 fine, have no contact with Ms. Boatman, stay away from the location, and report to probation every month for the remainder of 12 months. It's not just a fine.
I guess.
Do you still want to proceed, or I can have the case reset for trial?
I'll
It's
go
12
ahead.
months probation, not just the fine.
I ain't gonna do it right now. It don't matter. Yes, come on. We can go ahead.
No, you're not gonna come on. I want to make sure you understand. If you
I
don't
understand.
understand,
I understand.
okay.
I understand.
All right then. If you decide to plead guilty to these charges, you would have to give up your constitutional right to a trial. You will not have the opportunity of going back to a court of law to face a judge or a jury, to have the assistance of counsel so that you can confront your accuser, challenge the evidence brought before you, be able to present any defenses and arguments on your behalf, and also to have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
Are you entering this plea freely, willingly, and knowingly?
Really?
Willingly and knowingly?
Yes.
How do you plead to one count of misdemeanor terroristic threats and acts with regards to Shamika Boatman?
I did.
I'm sorry?
I do.
Again. Mr. Goodwin, how do you plead to that charge?
Guilty.
How do you plead to one count of willful obstruction of a law enforcement officer?
Guilty.
On the terroristic threats and acts, your sentence is 12 months to serve 60 days, credit for time served 16 days. You have an additional 16 days, correct. He has an additional 16 days to serve at the jail, after which he will be released to either the Bibb County or DeKalb County hold, whichever county picks him up first. After he has resolved all outstanding holds, he is to report to the Fulton County Probation Office immediately upon his release. He can report on a Monday, a Tuesday, or a Thursday, and he must report before 3 p.m. While he is on probation, he will pay a $300 fine with a minimum payment of $50 per month, plus his probation fees and any court costs. He's to stay 200 yards away from Shamika Boatman. He's not to contact her in any way, form, or manner, including in person, mail, email, phone, texting, and even on social media or through a third party. He's to stay 500 yards away from 2210 Sullivan Road in Atlanta, Georgia. If he violates any of these conditions, he will be his probation will be revoked and serve out the rest of the time in jail or in prison. With regards to the obstruction charge, it will be 12 months concurrent, and he's required to pay a $300 fine. He will remain on active probation, and he will be required to report every month. That concludes your sentence. Thank you.
Thank you, Your Honor.
Your Honor, if we could just jump very briefly to position 36, Joseph Woodruff. Mr. Woodruff's mother is here in the court, but she has to go back to her job. But there was an announcement on that from PD McLean that there was going to be a social worker visit. And so I wanted to just kind of get that moved along so we could release Mr. Woodruff's mother.
Ms. Vigilette, is that Mr. McLean or Ms. Vigilette's client?
It's Mr. McLean.
All right, Mr.
Yes, Your Honor. I don't think he can make it through a plea.
Okay.
I do want the social worker to confirm my notion.
All right, I'll reset it to May 2nd. Should I put it on the 11 a.m. calendar?
Yes, Your Honor. I think that would be.
It'll be a 1 week reset to the 11 a.m. calendar.
Right.
All right, Mrs. Woodruff, you are free to go. We will address this case again next Thursday at 11 a.m. Thank you.
Thank you.
All right. Mrs. Thomas, do we have anyone from probation yet?
Yes, Your Honor, I'm here.
Oh, Officer Barnes. Okay, sorry about that. There we go. Okay.
I apologize about that, Your Honor. I had stepped away for a second.
No, it's perfectly fine. We have long gaps between your cases. We are addressing the young lady at ACDC, Brittany Morris, and this was positions 5 and 6. Miss Morris was convicted of disorderly conduct, and I believe her disposition was on January 17th, 2023. How are we, why is the state seeking a revocation, and what's the recommendation?
Your Honor, Ms. Morris was before the court on January 17th, 2023, and was sentenced to disorderly conduct and simple battery. She was ordered to pay a restitution amount of $325 to the victim in this case. Ms. Morris last reported on October 20th, 2023. There was a warrant that was issued on December the 6th of 2023. She has an outstanding balance of $249 on her restitution payment and a total of $499 left on her supervision fees. 41 days left on this particular case. Probation respectfully asks that you continue her on probation and to at least try to make the payments in full within 2 weeks.
All right, looks like she was convicted of disorderly conduct only. No violent
Yes,
contact and
yes.
$300, and her probation would terminate once she paid off restitution. Mr. McLean?
I believe she would like to accept that, Your Honor.
All right, this will be marked as a probation violation. She is to report to probation on Monday at 132 Mitchell Street in downtown Atlanta. She has 90 days to pay off the remainder of the $249 of restitution. She will report every month and pay her probation fees as well. The sooner she pays off the $249 in restitution, the sooner her probation will terminate.
Yep.
Do you understand, Ms. Morris?
Yes.
All right, your first report date is, today is Thursday. You have to report on Monday.
Okay.
All
Your
right.
Honor,
Yes, Mr. Barnes?
I apologize. You said within 90 days?
She has 90 days to pay off the $249, but she has to report every month beginning on Monday. And she needs to be up to date with her probation fees.
Okay.
Once she has paid off all her probation fees and her restitution, her probation will terminate.
Yes, Your Honor. She has 41 days remaining.
She has how many days?
41?
Oh, 41 days. So I'm afraid I'm gonna have to reduce that to, and is she being given credit for any time that she's been in jail?
She has.
Excuse me, Judge. Navi Young, the victim that's in the case, she is in the Zoom and she is wondering if she dropped the case. She don't want to accept no payment from Brittany Morris.
Who is this?
This Brittany Morris' sister, Navia McGee. She is on the Zoom at this moment. She in the chat.
I can't see you. You need to, this is a Brosian Morris.
Yes.
Who are you?
I'm the sister of Brittany Morris. Navia McGee is the victim in there. She in the Zoom.
I can only accept it if Miss McGee shows up on Zoom. I can't accept your statement for it.
Okay, Navia.
There we go.
Where is the victim? Nabi,
I'm here.
Where?
She's wearing a blue
All right, there, I see her now. All right. All right, Miss, I don't know. I've never met Navia McGee, so is everyone comfortable that that's Navia McGee?
Probation is not, Your Honor.
All right, Miss Navia McGee, if you want to send us an ID that you are who you are, then I can accept that. But right now, I have no idea who you are.
How do I send my ID? In a chat?
Your Honor, I will give Miss McGee my email address. She can send it to me.
Okay, all right. Okay, Miss McGee, go ahead and you'll see an email address in the chat. You can send that to her. And Miss Morris, this is still going to be marked as a probation violation. We're going to have you report to probation on Monday. Now, between now and Monday, if probation, if Mr. Barnes, if you're satisfied that's Navia McGee, then we can terminate probation immediately. Miss McGee, where are you? Where did she disappear to?
I'm here. I don't know how to get back to the camera. 1 second.
Okay, you're on camera.
Okay, I'm here.
All right, raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right. Subject to you submitting your ID to probation, Ms. Morris's probation can terminate if you decide that you do not want the restitution. Now, is that the understanding that you no longer need the full restitution?
Yes, that's fine.
Okay. Mr. Barnes, I'll leave it in your capable hands. If probation's terminated, if you receive ID and you accept that representation.
Thank you, Your Honor. I will.
All right, thank you. Ms. Morris, please report to probation on Monday, either to confirm that your probation is terminated or that you continue on probation, okay?
Yes, ma'am.
Thank you. All right, Ms. McGee and Ms. Morris, you're free to go.
Thank you.
Thank you.
Jail court iPhone, that was Ms. Vigiletti's client on the add-on calendar.
May I, Judge, I'm sorry, I've been trying to find a way to politely interrupt. I do need to speak to jail court's iPhone. I am logged into Zoom. If I may speak to him very briefly.
Okay, let's see where you are. Is it under Olivia?
It is, and I just started my camera, so you.
Okay, Miss, I think it's Miss Champion who is Miss, it's Miss Champion. Miss Champion?
Yes, ma'am.
Place Olivia and jail court iPhone in a breakout, please.
Okay.
Thank you.
Thank you, Judge.
Jail court iPhone, you're going to see a message on your screen to join a breakout so counsel can speak to a client.
Okay.
All right. Any chance we could get Ronnie Smith, probation? In courtroom 2 or some other location? No? Okay.
Off the floor, Your Honor.
All right. Mr. McLean in courtroom 2. We have
He always repeats.
Ronnie Harris?
Ronnie Smith.
Oh,
Ronnie Smith.
yes, correct. He's on the floor.
Your Honor, he has 2 cases on the SAP and he has 2 positions as normal on the probation matter, and we can go forward with the probation matter, and then we're going to be entering not guilty pleas on the SAP case.
All right. I don't do that piecemeal. I just do them all at the same time. So probation, please take a note that he's got 2 open cases right now on SAP calendar as well. And that would be positions 27 and 28 is the criminal trespass and battery family violence from October and November 2023.
Thank you, Your Honor. 1 second, please.
All right. In the meantime, Mr. McLean, we have position 14 and 15 at ACDC. Jenna Hoyt. Jenna Hoyt, if you please come up to the screen. Ms. Jenna Hoyt is position 14 and 15 on the SAP calendar. Ms. Hoyt, cases are 27 CR 1164F, in which she is accused of unlawful conduct during a 911 call by using obscene, vulgar language to intimidate or harass 911 from February 7th, 2022. And her second case is from November 28, 2023, and that is a bench warrant 24 FTA 451. I understand that Ms. Hoyt intends to enter a not guilty plea. Ms. Hoyt, you've been advised of your rights and your attorney is Mr. McLean. Mr. McLean, are you planning to file a waiver of arraignment?
Yes, Your Honor, we have the forms. I can file those as soon as we get to a proper machine. I'll scan those in and forward them.
All right. Oh, just 1 second. Ms. Hoyt, your attorney will be entering a not guilty plea with regards to both cases. And the other matter we're going to address right now is your bond. All right.
Are those 2 related? Aren't they the same thing?
One is the original charge, and the other one is a warrant for failure to appear in court. And it's 2 separate cases. One's the original charge, and the other one's what we call a bench warrant or a failure to appear.
Which was when?
And November 28th, 2023.
Right.
All right. Mr. McLean, are we still addressing bond matters, or shall I further notice the cases for trial?
Your Honor, on bond, we would like to address that. We would request a signature bond in each of the two positions for the reason that she believed that this matter basically her description to me of what her belief was about the case was that she had done the requirements laid out. It sounded like she was on a diversion track. And if that's the case, and if her, since her belief is sincere in that, she can get proof that she did X, Y, and Z as requirements. And then the task would be to find any kind of documentation of a diversion track. We just couldn't do that, on one day's notice. But she does believe that she had completed the requirements to earn a dismissal.
My fiance is actually here. I can see her name. I do have all the proper documents. I did the 30-day in-house rehabilitation, the 28-day program for alcohol and substance abuse in Niagara Falls, New York. That was inpatient. I also did the 30-day in a hospital mental assessment. I have gone for over 15 years for mental health. I'm on a medication.
All right, Ms. Hoyt, I'm going to pause for a moment. Ms. Falk, was there a diversion? Was this individual in a diversion program?
That's my fiance too. She has all the papers.
I've never heard of a diversion program that has what she has just described that we would have offered. But if there is some documentation that Ms. Hoyt's fiance can send me, Ms. Laney, I'm going to put my name into the chat, my email address, so that you can send me an email with the documents that you have.
Okay, I sent it this morning to the address in the chat already, melissa.grace@fultoncountygeorgia.gov.
That would be the wrong address. Okay,
Right.
You're going to get an email address in the chat and you can send it there. All right, Ms. Hoyt, we're going to hold off on your case until Ms. Falk has had a chance to review these documents and see how she wants to proceed with your case. Presently is further notice for trial. I'm still going to leave the case on this calendar until we get a decision from the prosecutor.
So what we're looking at here, if I did all the required.
Ms. Hoyt, I don't know why you did those programs, whether it was
My probation officer.
No.
My probation.
You were not convicted in this case. There is no conviction. There is no probation officer. So
Yes, I
need Miss Laney to send the documents to the prosecutor so that then she can tell me how she wants to proceed with this case. If you want to keep on talking, it's gonna have no impact on how I move forward with your case. So please go back and sit down in the chairs right there. Thank you.
Who was I speaking to?
All right, Mr. McLean, do you represent position 16, which is
Mr. King.
Mackenzie King?
Yes, Your Honor.
All right. All right, Mr. Mackenzie King is accused of battery family violence from August 3rd, 2023 in case 24 CR 699G. Mr. King, you have the right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Michael McLean. Do you see Mr. McLean on the screen, Mr. King?
Yes, ma'am.
All right. And this is going to be a negotiated plea, if I'm not mistaken?
Yes, Your Honor.
All right. Mr. King, if you please raise your right hand, do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Falk, what is the recommendation?
Yes, Your Honor. Can you give me the position number again?
16.
Thank you.
Mackenzie King, yes.
Received. So the recommendation on that case, Your Honor, is 12 months served 154 days, credit for time served 77 days. That is from February 9th of 2024 until today. Balance probated family violence intervention program, 60 hours of community service. No further contact with Jaquita Edwards. stay away from 138 Lamar Avenue Northeast, number 1 in Atlanta, and no firearms. We would like to sound for Ms. Chiquita Edwards, and we do ask the defense to stipulate to venue, factual basis, and identity for the purposes of this plea. That's all for the state.
For said purposes, we do so stipulate.
Right, Ms. Edwards? All right. Mr. King, have you consumed any medicine or alcohol?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
And are you satisfied with your legal services?
Yes, ma'am.
If you decide to plead guilty to this charge of battery, family violence, it will go on your criminal history record. And in the event you are arrested for any subsequent offense, this could be that new arrest could be a felony charge. Has that been explained to you?
Yes, ma'am.
And are you still willing to move forward with this plea freely, willingly, and knowingly?
Yes, ma'am.
Also, you would have to give up your constitutional right to a trial in front of a judge or a jury. By pleading guilty, you will not get the chance to confront a judge or a jury, confront your accuser, to be able to challenge the evidence brought against you, and have the state carry its burden to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of battery, family violence?
Guilty.
All right. Mr. King has a hold for probation violation at the present time. Is that your understanding, Mr. McLean?
That is correct, Your Honor.
All right. Once his probation hold has been resolved, he must report to probation upon his release, and he reports on either a Monday, a Tuesday, or Thursday. He must report on the first available business day upon his release, and that would be before 3 p.m. While on probation, he will immediately enroll in a domestic violence intervention program within 30 days of being released, and he must complete that program without any breaks. He will report to probation every month. He will also complete 60 hours of voluntary community service, and he must complete a minimum of 10 hours per month and 10 hours every month thereafter in order to complete the 60 hours of community service within the time allotted for probation. At all times, he's to have no contact with Chiquita Edwards and to stay away from 138 Lamar Avenue in Northeast Atlanta. And neither time is he allowed to possess or own any firearms. That would be a sentence. Thank you, Mr. King. All right. Ms. Vigiletti is still in conference. I think, let me see. Mr. Barnes, did you make a decision on Ms. Hoyt's case?
You talking about for Brittany Morris?
Jenna Hoyt? Yeah. If you receive, no, sorry, it wasn't Jenna Hoyt. It was Brittany Morris, yes.
Yes, yes, Your Honor. I did receive her ID, Your Honor. Asked for Ms. McGee to just send me a brief statement stating that her intentions, so we can at least have it in writing. But I am satisfied with the ID.
Okay. All right, Ms. Morris, you'll be released and report to probation on Monday before 3 p.m. And there they will give you your decision as to whether you continue on probation or it's terminated. Officer Barnes, once you receive the statement from Ms. McGee, then it'll be, if you believe that she is waiving any rights to collect any additional restitution, please terminate probation.
Yes, Your Honor, will do.
All right, thank you. That concludes the case with Brittany Morris. Moving on to, let me see. I don't see Ms. Vigiletti back yet.
Here I am, Judge.
Oh, okay.
I'm just wearing all black today, so.
No, it's not it. I was 1 minute I saw Mr. McLean, now it's you. Okay. We were dealing with jail court iPhone. ACDC, I'll be right back with you.
Okay.
All right.
This is position 31, Mr. Antoine Slayton. If I may very quickly, Ms. Falk, positions 12 and 13, Jermika Hickson is also at Jail Court's iPhone. And I just wanted to draw your attention to the issue. I believe the recommendation is for a different client in error. And I've sent you an email with more details.
All right, thank you.
Thank you.
So are we addressing the add-on, Mr. Slayton?
Yes, this is Mr. Antoine Slayton. I'm sorry, he was position 31 on Tuesday. He's add-on position
Right.
2, I believe, today.
And how are we proceeding? Is this going to be a plea?
Yes, Your Honor, Mr. Slayton would like to enter the plea as negotiated on Tuesday.
All right. Is Jail Court iPhone on Zoom? I'm sorry, I got two screens going. There we are. All right. Mr. Anton, yes, sir. All right. Mr. Anton Slayton, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right. Madam Prosecutor, Ms. Falk, what is the recommendation for Mr. Slayton? You can put your hand down.
Yes, Your Honor. The state's recommendation on that case is going to be on count 1, 12 months concurrent with count 3. As to count 2, 12 months concurrent with count 3. As to count 3, the battery, 12 months to serve 90 days, credit for time served 18 days. That's going to be from April 5th, 2024 until today. Balance probated, stay away from the Shell gas station at 496 Plasters Avenue in Atlanta, Georgia. Also, we are requesting 12 weeks of anger management courses. We would ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea. And we do have a no further contact on that, Your Honor. I believe that's going to be, Your Honor can just give me a moment.
That gentleman's name is Aqib Habib.
Yes, Aqib Habib is going to be the person who is who does work at that Shell gas station. I believe he may be the owner, but I'm not sure. And I would like to sound for Mr. Aqib Habib at this time, Your Honor.
Mr. Habib? I don't see anyone with that name on Zoom. All right. Ms. Vigilante, do you stipulate to the factual basis, venue, and ID?
We do stipulate for the purposes of the plea, Judge. I do just want to very quickly note, credit for time served was 18 days on Tuesday, so I believe today that would make credit 20 days.
Just 1 second. This is 24 CR 001715C. And he's got a second case. I don't know if that's been resolved. 23 CR 004684C. Okay. Does he have a revocation at the present time?
Not that I am aware of, Your Honor. He is on probation already, but has been reporting as needed.
It looks like it was addressed on December 12th at 9 a.m. Okay. I'm assuming he doesn't have a probation hold then.
He does not.
Okay. All right. This is 24 CR 001715C. Mr. Slayton was accused of criminal trespass, battery, and terroristic threats and acts. Mr. Slayton, have you consumed any medicine or alcohol?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
Is anyone forcing you to take this plea offer today?
No, ma'am.
If you decide to enter a guilty plea to these charges, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not get a chance to have the assistance of counsel to go back to court, confront your accuser, challenge the evidence brought against you, present your defenses and arguments, and have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of criminal trespass, terroristic threats and acts, and battery?
Guilty.
Counts 1 and 2 will be served concurrently with count 3. On the battery charge, your sentence is 12 months to serve 90 days, credit for time served 18 days. So you have additional time to serve at the jail. Once you are released from the jail, you will report to probation on the first available business day, which will be a Monday, a Tuesday, or a Thursday. Failure to report will result in another arrest for probation violation. Do you understand, sir?
Yes, ma'am.
While you're on probation, you are to stay 200 yards away from the Shell gas station at 496 Plasters Avenue in Atlanta, Georgia, and you're not to have any contact with the employee or the owner known as Aqib Habib. Do you understand, sir?
Yes, ma'am.
And you are to complete 12 weeks of anger management classes. You must begin those classes within 60 days of being released. So you must show proof that by your second or third probation visit, that you are enrolled in a program to do anger management classes.
And Judge, if I may just, I do believe he's been here for 20 days, not 18 days.
Any objection to 20 days, Ms. Falk?
I'm muted. Let me just check something really quickly and I can let Your Honor know.
Thank you.
It probably is 20 days if it was reset. That is correct. I think I was using
20 days. Yeah.
that I was copy and pasting the reset date. So yes, it would be 20 days today.
All right. So the sentence will be to serve 90 days, credit for 20 days. So that means he has 25 more days to serve at the jail. All right. Thank you. Okay. Thank you, Mr. Slayton. Real Court iPhone, do we have another case?
Yes, we have position number 12 and 13, Mr. Hickson.
12 and 13, okay.
Your Honor, I can just explain my announcement briefly. Mr. Hickson was arrested shortly after the cyber attack, and the paperwork uploaded regarding his case also includes paperwork for other arrests for other clients. And so the offer that says to stay away from the days in and to have no contact with Manoranjan Metu it's just not related to what happened with Mr. Hickson. He is accused of an interaction on MARTA, not at the days in. So I believe Ms. Falk is putting together a updated recommendation for Mr. Hickson.
All right. Do we have one updated already, Ms. Falk?
Not so fortunate, I'm afraid. I am actually looking at that right now so I can give the updated recommendation. So it'll just take me about 5 minutes.
All right. Jail Court iPhone, we just want to get the recommendation from Ms. Falk, so we have to hold off on Mr. Hickson. Do you have another case we can address?
No, those are the only two on this side.
All right. Unfortunately, we have to hold because we don't have an offer to convey to him at the present time. Would that be additional? Additional jail time?
Sorry. Yes. No, Your Honor. I'm actually ready to go.
Oh, okay.
Let me just communicate the new offer to PD Vigiletti.
All right. Ms. Vigiletti, as soon as you get the offer, we can place you in a breakout with Mr. Hickson. So Jail Court iPhone, please hold.
Okay.
All right. Ms. Vigiletti, I know you're going to have to go into a breakout very soon. Are you ready to, Ms. Falk, have you had a chance also to look at the Jenna Hoyt case?
Yes, Your Honor, I did. And I actually do have an announcement for that as well.
All right, Jenna Hoyt, please come back to the seat. And her attorney was Mr. McLean. Yeah, I see your hand, Mr. McLean. Yes, Ms. Falk.
So Your Honor, in this situation, I did have an opportunity to look through the paperwork. It was quite fuzzy, but I was able to see that apparently the communications are between Ms. Hoyt's fiance and probation officers. None of the communications appear to be with my office. None of them include any discussions about an offer for my office. And so I did communicate back with Ms. Laney that through the chat that it doesn't appear that any of the communications going back and forth that she presented to me have anything to do with any agreement with the Solicitor General's office. It all appears to be agreements that were made with probation. It looks like she was on 2 different probation cases and was kind of doing things for one probation office and then requesting that the thing she was doing applied to the other probation in Georgia. So it looks like she was on probation in maybe 2 different states. And so that has nothing to do with this case or our offer. So no, she was not on pretrial diversion with us.
All right, Mr. McLean, how would you like to proceed?
Well, that sounds like it was a big mess of confusion with sincerity, however, and we would like to, it might be best to just plead not guilty today and ask for a signature bond, Your Honor. She didn't do this in bad faith. Now, she was unavailable apparently for court on that day, and she did have an explanation for that. Either Miss Laney or Mr. Hoyt had an explanation if they would provide that. The court date was November the what?
Sorry.
Flip back to that. Let's see. What number was that? 16?
November 27th, 2023, she failed to appear for her jury trial on November 27, 2023, before Judge Eric Richardson.
Ms. Hoyt, was that something about an address change, or what was that? That address changes had been provided to somebody, but of course it didn't get to the clerk?
Correct. My probation officer, Garrell Brown from Fulton, he was communicating with Forsyth. I guess that's where it wasn't from 2 different states, but I did tell Mr. Garrell that my lease was up and I was headed back to New York. He said, go on, carry on with what you need to do. So that's when I entered into the 28-day program. My insurance was also from New York too. I do live in both places, but now my fiance and kids are here in Georgia. But
the more I hear about it, the more it sounds like there was a transfer of probation supervision on something else from one place to another. And the defendant thought that it included this case.
Mr. McLean, have you conveyed the offer to your client?
Let's see. I believe I did, but it is time served, balance probated, do an evaluation for alcohol and drug abuse and treatment if the evaluator recommends it. And of course, it's not required in treatment if the evaluator does not recommend it. 40 hours community service, I believe that's it.
Your Honor, that's everything that I just did do. I just did.
Miss Hoyt, you did it for some other case.
I was talking to a parole officer.
You did it for some other case.
I did not. I spoke
Yes,
to him
okay.
every month.
Then in that case, we're just going to reset the case for trial because she doesn't get it.
No, I don't understand. I'm not getting it.
You had other criminal cases pending against you. And on this particular case in Fulton County, where you were arrested for unlawful conduct during a 911 call on February 7th, 2022, there is no conviction. You have not been convicted. So if there is no conviction, there is no probation. So I do not know with whom you were communicating.
Mr. Hoyt, it's just simply an open case that needs.
Correct. It is an open case, and you did not show up for your jury trial on November 27th, 2023. Either because I have no idea why you didn't show up.
Because she's in jail in Forsyth County.
You guys should have taken me if my.
So, bond remains the same, and this case is further notice for trial. Thank you.
I'll speak with the defendant further. Thank you, Your Honor.
All right.
I didn't want to interrupt. I have not been placed in the breakout yet.
I'm so sorry. We were addressing this case. And with whom do you need to speak? Jail Court iPhone? Okay. Ms. Champion, if you could place Zoom panel Olivia with Jail Court iPhone. All right.
Thank you.
Your Honor.
Mr. Barnes, yes.
I apologize, Your Honor. I just want, if I can speak with Mr. McLean regarding Mr. Rennie Smith. We're going to be changing that recommendation.
All right, Ms. Champion, could you place probation officer Jay Barnes and courtroom 2 in a breakout session, please? Mr. McLean, you're gonna have to click on the screen to join a breakout.
Okay, right, there's nobody here, so I'll just click on the main screen instead of doing the phone. Sure.
Yeah. As soon as you see the message on the screen.
Right.
ACDC, who did you place in there?
Position 30 and 31, Kayla Williams.
Okay, as soon as one of the PDs are available, we'll be able to address Ms. Williams. Mr. Barnes, Mr. McLean, do you see the message to join the breakout?
I saw one thing that said it had a blue leave and I clicked on the OK next to it or clicked on the blue OK, whichever it was.
Oh, he's clicked the right one? Okay. Mr. Murphy, you are here for the 11 a.m. calendar? Mr. Dennis Murphy?
Yes, Judge.
All right. Ms. Champion, can you open up another breakout session for Mr. Murphy, Ms. Shelley Falk, and Kasha and Kia Burgess? Kasha and Kia Burgess, could you please start your video? Ms. Falk? All right, we're going to go into a breakout session for Mr. Murphy's case at 11 o'clock.
They're just believing it. They're just believing it.
Right.
Zoom stuff may work on this. I don't know when the county commission designated these courtrooms in the jail as courtrooms. Maybe they legally did that, but does that last forever? And this is not a legal courtroom anymore, ever since nobody's been able to be back there.
Ms. Graves, what have I missed here? I thought we were handling Mr. Hickson. I see no one. I think we're missing a lot of folks.
Ms. Vigilante.
Yeah, I believe they're maybe addressing the competency calendar. I'm not sure.
Yes, they're currently in the breakout room discussing the competency calendar at this time.
Okay, did you guys want me to do a Russell on 4 North? Last name Russell?
Yes, Russell is on the calendar for today. He needs to come. Yep.
Okay, yeah, he's not on this calendar, but yeah, they're pulling him out now.
He's
What
not on your full sheet.
Yeah, what position is he?
He is position, I'm grabbing him right now. Let's see. Anthony Russell, position 25.
Oh, okay. 25, yeah, they got him listed on 4 South.
Yeah, I had a lot of trouble finding people yesterday. It seems like maybe there was a lot of moves, but I did talk to him. He should be pretty much ready to go. If we are able to get him, that would be great.
Yeah, they're grabbing him now, yeah. They, on this one, they got him listed on 4 South, not 4 North. But yeah, they're grabbing him.
See, and they told me he was on 3 South yesterday. And then in terms of our combative fellow, is his name Harris?
Yeah, Harris.
Officer Norris offered to take me up there and maybe we can be on screen with the judge. Maybe the judge can see him refusing to speak to me.
Oh, good luck.
He's
Yeah.
not even, well, you'll see when you get up there.
Yes, I've tried to speak with him. I think we just need to put a bit of proof on the record that we are all
Right.
trying our best with this gentleman.
Right, no, I get it, I get it.
You want any crackers or anything on the temp machine?
Okay, thank you.
Russell?
If you have Mr. Russell, I'd like to talk to him again.
Yeah, he's right here. He's right
Okay,
here.
let's do that briefly. Is that possible, Ms. Champion, to put courtroom 2 and Mr. Russell in a breakout room quickly?
It's already a breakout room created. Just rejoin that breakout room.
Oh, I'm not sure how to do that. Oh, I see. Okay, thank you.
Mm-hmm. Jail court iPhone, rejoin the breakout room.
Yeah, how do you do that from the phone?
You should go down where it says, I think it says in, and you click that and it should say to join the breakout room.
Hold on. Then. No, I don't see it on this.
Okay, hold on then, I'll just put you guys in.
Okay. Oh, okay, I think I did. I think I see it. It's join breakout room.
I'll put you in.
Are you able, Officer Goldie, to rejoin this breakout room with me?
Yeah, she's gonna put me in.
Okay, perfect. Thank you.
Yeah.
Ms. Champion,
Yes, ma'am.
I'm gonna take the ones that already finished back to the floor, and I'll
Okay.
come back with the other two females that I have left.
Okay, okay.
All right, thank you.
Hey, Miss Champion, can you add me to the breakout with Shelley and the judge?
Okay, yes, Mr. Walker.
Thank you.
All right, ladies and gentlemen, we are going to resume our state all-purpose calendar and jail court iPhone and Miss Vigiletti, you were in a conference. Are you ready to proceed?
Yes, we are, jail court iPhone, we are.
Miss Vigiletti? Oh, was that Mr. McLean's client? I'm sorry, y'all have to refresh me. I've just
This
finished.
is, he's Vigilante's client.
They went with a cell phone to see if they could go to the doorway and talk to an Abraham, what was that last name?
Harris?
Harris.
All right. Is that your client? All right, jail court iPhone, Miss Vigiletti apparently has gone off to talk to another client.
Okay, well, I guess we'll come back to them.
And I'm sorry, what was this gentleman's name at jail court iPhone?
This is Hickson, I'm sorry, yes, Mr. Hickson. Positions 12 and 13.
Okay. Mr. McLean, do you represent positions 30 and 31 and 34 and 35?
Let's see, have my
Yeah,
master.
those are yours.
Kayla,
31, that's
right, that's 30 and 30.
Kayla Williams,
Right, that's a plea.
and then Tarika Wingfield.
That is also a plea.
Okay. Kayla Williams, could you please come forward to the screen? This is State versus Kayla Williams. She's got two matters before us. These are positions 30 and 31. The first case is 23 CR 5837Y. She's accused of criminal trespass causing damage to property on September 28, 2023. And Ms. Williams also has a bench warrant, 24 FTA 452. Ms. Williams, you've been advised of your right to remain silent, and your attorney is going to be Mr. Michael McLean. May I place you under oath for purposes of the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Walker, what's the recommendation for position 30?
Yes, Your Honor, I have 12 months to serve, 24 hours, credit for time served of,
24 days, you mean?
yes, 24 days.
Okay.
Credit for time served of the period from 9/28 to 9/20. Well, I'm sorry, this is kind of confusing.
Oh, it's 12 months to serve 24 days, credit for time served 12 days.
Okay, thank you.
Okay.
Balance probated, stay away from Bubble's Food Market,
Mhm.
and that's located at 37 Lyndhurst Drive. Mental health evaluation, any necessary treatment, and 40 hours community service.
Mr. McLean, do you stipulate to the factual basis, venue, and ID, and does your client accept these terms?
For the purposes of the plea, we do so stipulate, and she does.
All right. Ms. Williams, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And is anyone forcing you to take a plea today?
No, ma'am.
If you decide to plead guilty to the charge of criminal trespass causing damage to property, you will have to give up your constitutional right to a trial, to confront your accuser, to challenge the evidence brought against you, to be able to present any defenses and arguments, and have the state prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
And how do you plead today?
Guilty.
Your sentence is 12 months to serve 24 days, credit for time served 12 days. If you have no other holds, you'll be released within 24 hours, but you must.
I'm gonna go home.
Cortez Goodman? All right, sorry about that. Ms. Williams? You are to report to probation on Monday. Today is Thursday, so you need to report next week on Monday before 3 p.m.
Yes.
That what date is that? May?
Yeah, give me a moment. Someone is interrupting. Miss Grace, could you place Cortez Goodman in the waiting room and we'll let him in when we are ready? Place Cortez Goodman in the waiting room. Thank you. All right, as I was saying, today is Thursday. You will report to probation on Monday, which is going to be April 28th. 29th, excuse me. 29th. But you must report before 3 p.m.
Yes,
While
ma'am.
you're on probation, you will stay away from the Bulbul's Food Mart. Okay, you cannot return to that location, okay?
Yes, ma'am.
You are also to do 40 hours of voluntary community service at any nonprofit agency. It cannot be a church and it cannot be a school.
Oh, okay.
And you must begin with at least 5 hours within the first 30 days and do a minimum of 5 hours every month.
Okay.
You're also to go to a healthcare facility like Grady to do a MH evaluation and submit yourself to any treatment that's required.
Okay.
And that must be done within 30 days of release.
Okay.
All right?
Yes, ma'am.
Thank you. That concludes your sentence. And your bench warrant is null prost. Thank you.
Okay.
All right, Ms. Wingfield?
What, records I have. You know, with who?
This is State versus Tarika Wingfield, case number 23 CR 3752J, in which she's accused of theft by taking from June 12th, 2023. She's also got a bench warrant matter 24 FTA 455 from September 27, 2023. Ms. Wingfield, you've been advised of your right to remain silent. Your attorney is Mr. McLean. May I place you under oath?
Yes, ma'am.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Walker?
I have 12 months to serve 38 days, credit for time served 19 days. Balance probated with the conditions of a stay away from the Family Dollar located at 6385 Old National Highway in South Fulton. No further contact with Byron. I will spell his last name Mariani. An anti-theft course and 40 hours of community service.
Mr. McLean, are those the terms to which your client accepts, and do you stipulate to the factual basis, venue, and ID?
They are, and we do for the purposes of the plea.
All right. Ms. Wingfield, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney services?
Yes, ma'am.
And have it been explained to you that if you accept this plea offer, you would have to give up your right to a trial, to confront your accuser, challenge the evidence brought against you, present any defenses you may have, and have the state carry its burden to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of theft by taking?
Guilty.
Your sentence is 12 months to serve 38 days, credit for time served 19 days. You will be released within 24 hours and you must report to probation on Monday, April 29th before 3 p.m. Probation is located at 132 Mitchell Street in downtown Atlanta. While on probation, you will complete 40 hours of community service at any nonprofit agency that's not a church and not a school. You must begin with at least 5 hours per month and do a minimum of 5 hours every month thereafter. You are also to stay away from the Family Dollar store at 6385 Old National Highway, have no contact with Byron Mariani, and undertake an anti-theft class. That class you must enroll in that class within 60 days of being released. Understood?
Yes, ma'am.
That concludes your sentence. Thank you.
Thank you.
All right, I think we are concluded with AC/DC. Thank you, Deputy Milton. Any word on Ronnie Smith with Officer Barnes?
Yes, Your
Yes.
yes, Your Honor. We are prepared to move forward, Your Honor.
I think there was a discussion of whether this, Okay, I don't have Mrs. Smith right now. So
Right.
are we moving forward with the probation revocation in addition to his SAP cases?
Yes.
All right. Mr. McLean, are you ready to move forward with the SAP cases and the probation revocation?
Right now, I thought we were going to reset for a hearing on the probation matters.
We can do that. We can do that. We do need to
All
get
right.
in contact with the victim in this particular, in the new case.
All right, position 7 and 8 are reset to May 2nd. Probation revocation calendar. And I understand on the SAP calendar for Mr. Ronnie Smith, Mr. McLean, you're filing a waiver of arraignment, would that be correct?
That is correct.
All right. And do you waive your client's appearance for purposes of this proceeding?
We do.
All right. So Ronnie Smith, oh gosh, let me see, what position was he on the calendar?
27 and 28.
Okay. Yes. On 27 and 28, Mr. McLean will file a waiver of arraignment. And these two cases are further notice for trial. And we will see Mr. Smith next Thursday on his probation revocation matters.
Very good.
Medical, who do we have, please?
Your Honor, that concludes my business. May I please be excused?
Yes, Mr. Barnes, you have a great weekend. Thank you.
You do as well. Thank you.
Medical, who do
We
we
have
have?
positions 12 and 13, Mr. Hickson.
Okay. Ms. Vigiletti, you have the conference with Mr. Hickson. How are we proceeding?
Yes, Your Honor, Mr. Hickson would like to enter the plea as recommended by the state this afternoon.
All right. Jermeka Hickson has case 24 CR 804A, in which he's charged with simple battery from February 16, 2024. And he's got a bench warrant 24 FTA 450 from March 7, 2024. Mr. Hickson, you've been advised of your right to remain silent, and your attorney is Ms. Vigiletti.
Your Honor, if I may, Mr. Walker, do I not have the recommendation for Mr. Hickson? The recommendation is an error.
You would need to speak up, Ms. Vigiletti, because you're competing with the sounds of shutting doors at
Oh,
the
I
medical
apologize.
unit.
This is the case, Judge, where the recommendation on the calendar was an error. And so Ms. Fox sent an updated recommendation in the chat. So I just wanted to flag that for Mr. Walker.
Okay.
Okay, well, I obviously don't have the information, so can you copy and paste it and put it in the chat?
And yes.
Thank you so much.
All right, so meanwhile, Mr. Hickson, I understand that you will accept the state's recommendation and enter a guilty plea. So for purposes of this plea, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. We ready, Mr. Walker?
Yes, we're ready. I have 12 months to serve, 28 days. Credit for time served, 14 days. Balance probated, an 8-week anger management course, of 40 hours of community service. I stay away from the MARTA located at 1400 Lee Street. And no further contact with Law. I will spell his last name, Hamdaoui.
Okay. Ms. Vigiletti, does your client accept these terms, and do you stipulate to the factual basis, venue, and ID?
We do, Judge, for the purposes of the plea. I did want to ask, Mr. Hickson is in the Hope House, which is a program, it's a very intensive program. He cannot work at the stage of the program right now. So I am wondering, Judge, if you'd be willing to waive the first 2 months of probation fees with the understanding that he is returning right back to the Hope House where he's in intensive residential treatment.
He will still be required to report to probation, but I'll waive his probation fees for the first 6 months.
Thank you, Judge.
Mr. Hickson, have you consumed any medicine or alcohol?
No, ma'am. No, ma'am.
Okay. Have you consumed? I know we're competing with a lot of background noise there. Have you understood what's going on in your case?
Yes, ma'am.
And are you satisfied with your attorney?
Yes, ma'am.
If you decide to accept this plea offer, you would have to give up your right to a trial. You will not be able to go back to court, confront your accuser, challenge the evidence brought against you, and have the state try to prove this charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of simple battery?
Guilty, ma'am. Guilty, ma'am.
I heard you. I heard you.
Okay.
All right. Your sentence is 12 months to serve 28 days, credit for time served 14 days. You will report to probation on Monday, April 29th before 3 p.m. to begin your probation. You have to do 8 anger management classes, 40 hours of community service at any nonprofit agency that's not a church and not a school. You must complete at least 5 hours of community service in the first 30 days and 5 hours thereafter. If you can do work at the Hope House, I will count that as community service. Do you understand? You are to have no contact with Mr. Jamal Hamdoui, and you're to stay away from the MARTA station at 1400 Lee Street. So if you're using MARTA, you cannot stop or get on a bus or train at the Lee Street location. Do you understand? Please unmute. Do you understand, sir?
Yes, ma'am.
All right. That concludes your plea.
All right, next we have position number 23, Mr. Anthony Russell.
Position 25, Your Honor.
I'm sorry, 25.
All righty. And how are we proceeding, Ms. Vigilante?
Mr. Russell would like to discuss the possibility of a non-negotiated plea this morning.
All right. This is 24 CR 1840Y, State versus Anthony Russell, accused of criminal trespass from April 11th, 2024. Mr. Russell, you have another open case, 24 CR 1789Y. And also, I believe there's a criminal trespass as well, involving the same victim. Mr. Russell, you have the right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Vigilante. For purposes of this plea, may I place you under oath? Please unmute medical. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Mr.
Yes, ma'am.
Russell?
Yes.
Thank you. All right. Mr. Walker, I understand this is a
Yes.
global recommendation for both these cases.
Right, since it's non-negotiated, can we have pretrial go first, please, with the history?
Pretrial, do you have Mr. Russell's criminal GCIC? See, I hope pretrial's on Zoom. I've not had to call them so far.
I am, Your Honor. I'm just
Oh, there
having
you go.
problems
Okay.
unmuting. Just a
No
moment,
problem.
please.
Okay.
Okay, there we go.
Yes,
All right. He has 57 cycles. The last arrest was February the 12th, 2024, out of Fairburn, Georgia, for a theft by shoplifting, a misdemeanor. There was no disposition for that arrest. He does have prior felony convictions. Sworn in 2020 for Terroristic Threats Act and obstruction of an officer. One in 2015 for possession of a firearm by a convicted felon and Terroristic Threats Act. And one in 2013 out of Coweta County for entering an automobile.
Oh, that's good. Plenty. Thank you very much. Mr. Walker, he's currently on $1,000 cash bond only, based on the violation of the bond in his other open case. What's the state's recommendation?
So for the global offer, the recommendation is 12 months to serve 90 days, credit for time served 15 days, balance probated, stay away from the incident location, 948 Hubbard Street, no contact with the victim, Mr. Patrick Mitchell, who's the victim in both cases. And I'm recalling this, or these cases rather, from the C calendar. I think we handled this case together, actually. In the first case that I believe that's on the add-on calendar, he was ordered to have a stay away and no contact with the victim. I believe that's also a criminal trespass. he left, or when he bonded out of the jail, he left the jail and went directly back to the victim's home, was banging on the window, calling him names, cursing and screaming. So we do have to for the victim, as this is his ex-boyfriend. He will not leave him alone. The last time he went straight back, disregarding his no contact and to stay away, and that's why a cash bond was issued. So we would ask the court to impose that 90-day sentence with the conditions of probation I requested.
All right, and Ms. Vigilante, what is the non-negotiated portion?
Yes, Your Honor, I will just note that Patrick Mitchell is here on Zoom, the victim in these cases. We are requesting a reduction in the jail portion of this sentence. I had a conversation with Mr. Russell. I also had a conversation with Mr. Mitchell. Both of them have told me they would like to have contact, that they would like to have no violent contact as well. But our primary request today is a reduction on the jail portion of the sentence. Mr. Russell actually suggested himself yesterday that perhaps he could attend anger management classes rather than spend additional time in the jail. He works at DHL in Fairburn. He does packing work. He's been there for several years. I'm extremely concerned about losing his job, especially because
Hang on. Yeah, Miss Vigilante, I'm sorry, you are competing with the door sounds right in medical unit.
Is it possible to just briefly mute medical? Thank you so much.
All right, just one second, Mr. Russell, can you hear your attorney? Okay, you need to speak louder, Miss Vigilante, because even with the muting, he's still competing with his background noise.
Sure, absolutely. And I'm sorry, I'm going to repeat myself a bit here to make sure that everything is on the record. But Mr. Russell himself actually yesterday suggested perhaps he could attend anger management while on probation rather than spending additional time in the jail. He's extremely concerned about losing his job. He works at DHL in Fairburn. He does packing work. He's been there for many years. They're holding it because he has been here for many years so far, but 30 additional days in the jail could certainly result in him being fired. I did speak to Patrick Mitchell, who I believe is on Zoom today. Patrick has said he would like to have contact.
Yeah, I'll hear from Mr. Mitchell. Anything else besides?
That is our primary request today, is amending the jail sentence to 30 days, credit for time served 15, and perhaps adding that anger management so he can do something productive in the next month, working and taking those classes.
All right, Patrick Mitchell, if you like to contribute to this proceedings, you need to unmute and start your video. Patrick Mitchell. All right.
And I could just address something briefly, because I just talked to the victim as well, and he said he wanted no contact. So I don't know what defense counsel is referring to and what conversation that is, but we have had contact with the victim, I think twice now, and both times he stated he wanted no contact. And he came to both of those first appearances.
Understood. We did speak late last night, Judge. I do.
Well, I wish you would chime in, because when I get two conflicting versions of what the victim wants, I don't have a resolution.
I totally understand. I'm going to shoot him a text. I wonder if maybe he's, I know he's been on since 9 a.m. I wonder if he had to step away.
So have I. So,
yeah.
So have you.
Shoot him a quick text here.
Last call, Mr. Patrick Mitchell. You need to start your video and unmute. Miss Champion, can you send, could you send him a start video prompt? Or...
Patrick just sent me a text that he's trying to get in.
He's already on. He just needs to unmute and start video. Miss Champion, just send him. There we go. All right, you need to be in a room with better lighting because we can't see you at all.
Okay, sorry. Can you guys hear me?
No. A little better, but
Okay, I'm
can you
sorry.
go face the windows? There we go.
Okay, I'm here.
Lovely, lovely. Stop walking. Okay. All right, sir, if you raise your right hand, please. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am, correct.
Mr. Mitchell, my name is Judge Lal, and I've had the pleasure of dealing with Anthony Russell twice already in jail. This will be my third time, at least that I know of, where he was first arrested and brought to jail because of an issue with you, and he was given a signature bond where he was required to stay away from you and not violate the conditions of the bond. Well, willy-nilly, in a very short period of time, he was back in jail. Either he missed me or he violated the conditions of his signature bond and had contact with you, and it was arrested again. And so the concern is that he doesn't appear to comply with a court order to stay away from you, the alleged victim in both cases. Do you have any comment?
I don't think I have to say at this moment. The no contact thing, I did want it like that for a minute, but when I spoke with the lady on last night when she called me, I went on have the sense that I just don't want a no violent contact order against him. So I would prefer that, but I never knew, I could do this. But other than that, it's a no violent order.
And if an altercation again occurs, he'll be back in jail. Would you want to have him contact you again?
I mean, yes, ma'am. That's fine.
Can you explain to me why that is? Because Mr. Russell seems to be getting arrested on your account.
Correct, exactly, makes sense. I just how can I put this? I just have a problem with the drinking issue. When it comes to drinking, that's when he started to act crazy. But other than that, I don't really want to see, nothing bad happen to him, just speaking personally. So other than that, Mr. Russell really not a bad person. He chose to do what he did and stuff like that. So.
All right. Thank you, Mr. Mitchell.
No problem at all. Thank you.
All right. Mr. Walker, anything else to add?
Nothing further, Your Honor.
All right. Ms. Vigiletti?
Nothing further from us as well.
All right. Mr. Russell, I am very impressed that the alleged victim is here to speak on your behalf, considering the 2 open cases you have and your blatant disregard of the bond order, which is why you got a $1,000 cash bond and risking your job and all your other resources at the same time. I'm going to accept the defense's recommendation that it would be 12 months to serve 30 days, credit for time served 15 days. You are to stay away from Mr. Patrick Mitchell. You are to enroll in a DVIP program and an alcohol and drug evaluation. You are to be subject to random screens for alcohol and illegal drugs. You cannot have any contact with Patrick Mitchell until you resolve these other issues. Do you understand, Mr. Russell? And if that's going to be my sentence, if you choose to accept it. But on the other hand, you also have a right to a trial. So we can unmute medical and he can let us know his decision.
Yes, ma'am.
Are you willing to stay away from Patrick Mitchell?
Yes, ma'am.
All right, Ms. Vigiletti, your client will be required to enroll in a DVIP and do an alcohol and drug evaluation, be subject to screening every month. And if he violates those conditions, he will be serving out at least 2 years in jail, because this is going to be a consecutive sentence.
Okay, understood, Your Honor. So 24 months of probation?
Correct?
Okay.
I just don't have a tremendous amount of trust in Mr. Russell's ability to comply with the court's orders. And I'm going to give him 24 months to prove otherwise.
Understood, Your Honor. Do you have any questions, Mr. Russell?
No, ma'am.
Okay,
Okay. So, do you stipulate to the factual basis, venue, and ID for your client, Ms. Vigiletti?
we do for the purposes of the plea.
All right. Mr. Russell, have you consumed any medicine or alcohol?
No, ma'am.
Have you understood the proceedings so far?
Yes.
And are you satisfied with your legal services?
Yes.
Are you entering this plea freely, willingly, and knowingly?
Yes, ma'am.
You understand that you'll be on probation for up to 24 months
Yes, ma'am.
and that you will have strict conditions of no contact and stay away, in addition to your alcohol and drug and your domestic violence program.
Yes, ma'am.
If you fail to comply, probation is authorized to issue a probation warrant, and you will spend the remainder of the 2 years in prison.
Yes, ma'am.
So it's imperative that you understand that you must strictly comply with probation, otherwise you're back in prison.
Yes, ma'am.
If you decide to enter a guilty plea to both cases, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not have an attorney represent you to go back to court to confront your accuser, challenge the evidence brought against you, to be able to present your defenses and arguments and any mitigating factors, and have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to criminal trespass in case 24 CR 1840Y occurring on April 11th, 2024?
Yes, ma'am.
How do you plead, sir?
I plead guilty.
How do you plead to case number 24 CR 001789Y, one charge of criminal trespass occurring on April 9th, 2024?
Guilty.
Your sentence for the case 24 CR 001789Y is going to be 12 months probation, to serve 30 days, credit for time served 15 days, to stay away from 948 Hubbard Street in Atlanta, Georgia, to have no contact with Patrick Mitchell, to stay 200 yards away from him, no communication with him, and not to contact him in any way, form, or manner, even on social media. You're to complete 40 hours of community service, to do the community service at any nonprofit agency that's not a church and not a school. You must begin with at least 5 hours of community service in the first 30 days and 5 hours every month thereafter. With regards to the latter case, 24 CR 1840Y, your sentence is 12 months probation consecutive to 24 CR 1789. And again, no contact with Patrick Mitchell. Excuse me, let me go back to the first sentence. I forgot to include. You're also to enroll in a domestic violence intervention program and to complete an alcohol and drug evaluation and submit yourself to any treatment. The domestic violence program classes, you must enroll within 60 days of being released, and you must continue to attend those classes without any breaks. With regards to the alcohol and drug evaluation, you must enroll in the evaluation. You must enroll in the evaluation within 30 days of being released and submit yourself to any treatment that's required. In the first 12 months of your probation, you will be subject to screening for alcohol and illegal drugs. Going back to the second case, 24 CR 1840Y, that's going to be 24 months probation consecutive. And again, no contact with Patrick Mitchell, and to stay away from 948 Hubbard Street in Atlanta, Georgia. If Mr. Mitchell changes address during this 24 months probation, you're required to stay 200 yards away from wherever he lives. During the course of the 24 months probation, if there is sufficient grounds to amend If you are passing your drug screens, if you're attending your classes, and you are complying with any and all treatment with regards to alcohol and drug abuse, then your attorney can file a motion to amend probation to allow for no further violent contact with Patrick Mitchell. But this cannot be done until you've completed the first 12 months of probation. Do you understand, Mr. Russell?
Yes, ma'am.
The sentence is strict because I have absolutely right now no trust in you to comply with probation. So your mission is to prove me wrong. Thank you.
Next, Your Honor, we're gonna do positions 27 and 28. And on the probation calendar, 7 and 8, Mr. Ronnie Smith.
All right. Mr. Patrick Mitchell, you are free to go. Please keep in mind that if you try to communicate with Mr. Russell in the first 12 months, the only thing that might happen is that he'll end up going to prison.
Yes, ma'am. Thank you so much.
You're free to go. Mr. Ronnie Smith, your attorney has filed an entry of not guilty and has filed a waiver of arraignment for your two cases, 22 CR 75208 and 24 PV 573. Oh, excuse me, that's the wrong case numbers. That was the probation.
Right.
Excuse me, his two open cases are 24 CR 16178 and 24 CR 16188. And in those two cases, your attorney has filed a not guilty, so there will be further notice for trial. Do you understand?
These are, Mr. Smith, these are the waivers. I've signed your name with your permission to saying that you are not guilty.
All right.
Okay?
Your probation violation cases, 22 CR 75208 and 24 PV 573 are going to be addressed next Thursday after your attorney speaks with you about the revocation issues.
Yes, ma'am.
All right. So it's reset to May 2nd. Thank you, Mr. Smith.
Okay.
Medical, do we have any other cases at that location? Do we have any more cases?
Stand by, we gotta grab the other inmate from another floor.
All right, we'll hold. Thank you. Ms. Vigiletti and Mr. McLean, while we're waiting, I'm just want to address the calendars. On the add-on calendar, position 1, Sappho Davis was a waiver arraignment and further notice for trial. Position 2, Timothy Rutledge was a plea. Positions 3, Anton Slayton. What did we decide to do with that?
Mr. Slayton took a plea today.
Okay. And then 4 and 5, Antronika Troutman, she was released, so those cases are further notice for trial. All right. On the probation revocation calendar, position 1 and 2, Darius Irvin is that was commuted to time served, so that's completed. Position, and so that's also includes positions 3 and 4 for Darius Irvin. For position 5, Brittany Morris, that is going to be continued on probation, subject to Officer Barnes terminating probation once he's satisfied with the victim's representations. So she needs to at least report on Monday. Positions, that was for position 5 and 6. Position 7 and 8, Mr. Ronnie Smith, that's continued to May 2nd. Okay. All right, now let's get to the long one. Position on the SAP calendar, position 1 and 2, Nathaniel Arnold is released and further notice for trial. Position 2, Tariq Barnes. I got Superior Court something 9 a.m. Are we resetting the misdemeanor case?
Your Honor, he had a conflicting simultaneous Superior Court matter So I knew that he would be going to that instead of to us.
Okay, so I'm going to reset his case to May 2nd. That is not going to jeopardize the plea offer since he's got a he would have to do additional jail time if he accepted it. So May 2nd.
Thank you.
Position 4, Braddock was a plea. 5, Chapman was a plea. 6, Dennis is reset to May 9th. Position 7, Isokbu was a plea. And 8 is null crossed. 9, Goodwin is a plea. 10, Grissom is a waiver of arraignment and further notice for trial. Position 11, Abraham Harris is.
Yes. Judge, I did go see him in person after you suggested we go to his cell directly. I have never done this, but I will not be representing him. From the first moment I saw him, it was an onslaught of gender-based violent language to me. We couldn't get him to calm down. If our office will continue to represent him, it won't be me.
Understood.
Your Honor, I'll give it a shot, or Mr. Bartels will. One of us will try that.
Case is reset to May 2nd. He can either appear through counsel if you want to waive his appearance, or we can do the jail court iPhone if they are able to take it to the jail cell.
Sorry, Judge, what case is this? Position 11?
Yes, Abraham Harris. And Miss Vigiletti is removed as can withdraw from the case. Not the public defender's office, just Miss Vigiletti.
Thank you, Judge.
All right.
And that's going to be for 5-2, correct?
5-2, correct. Position 12, Hickson. Position 12 was a plea. 13 was a null cross. Position 14, Jenna Hoyt, is a waiver of arraignment and further notice for trial. 15 is further notice for trial. Position 16, Mackenzie King, is a plea. 17, Robert Lee, is a waiver of arraignment and further notice for trial. Position 18, Roger Logan, was a possible plea. Are we still proceeding with that?
Yes, I believe that may be the client we are still waiting on from medical.
Okay.
And Mr. Walker, Ms. Falk and I discussed a negotiation this morning on that, so I'll forward you that email.
Okay.
All right. Position 19 and 20. 20 was a plea. 19 is a null cross. 21, Lucas, was a plea. 22, Tony Marshall. We've not addressed him, correct?
No, Mr. Marshall and Mr. Logan are on the same floor, so I'm hoping they're going to grab both of those gentlemen.
Okay. Position 23, Reiki Medrano, has not been addressed. He's been outsourced to Alpharetta.
I spoke to Alpharetta today, Your Honor, on the phone, and they refused to bring him. They said that he's being held on Roswell's request in Alpharetta, not on our request, so we have to get it approved through Roswell. He is going to be released tomorrow, so I do think maybe it makes sense because they refused to bring him today to further notice for trial for that case, just because.
All right, I'm going to reset him to May 2nd. He's either going to be released and further notice for trial, or if he's still got a bond, then he needs to be transported back to Wright Street.
Understood. Thank you.
Position 24, Calvin Richmond, was a plea. Position 25, Anthony Russell, was a plea. 20 for both his cases. 26, Timothy Rutledge, was a plea. 27 and 28 are reset, a waiver of arraignments and further notice for trial. 29, Darian Williams. Am I resetting it to the 11 a.m. calendar?
Not yet, Your Honor. I was hoping a social worker could talk to him. He might be able to do okay in a plea.
Today?
Let's give it a shot.
Okay, all right. Position 30, Kayla Williams, was a plea. 31 is a null cross. 32, Mr. Wilson is another one who is a little skittish about coming to us.
He wanted to talk to him yesterday, and he said, I'm sorry that I wasn't ready the last time I appeared in front of the court, and he says, I'm ready now, let's do a plea.
All right, so 32 and 33 is a maybe.
If they can put him on Zoom or bring him to the courtroom, he does wish to plead.
All right, sir.
This is simply a time served, balance suspended, and stay away from a Texas gun station.
All right. And then we zoom forward to position 33. And that's also Mr. Wilson. Position 34, Wingfield was a plea. 35 is null crossed. 36 is reset to May 2nd for a possible social worker interview. Is that correct?
Correct, Your Honor. That is correct.
For 36, Judge?
For 36, Joseph Woodruff.
511 to the competency.
There was some talk about putting him to 11 o'clock on what day?
May 2nd.
No, I have 511, Judge. Let me just double check that date too. Yeah, I have 511.
Do we don't, if 5/11 is a Saturday, I think what I meant was May 2nd, 5/2 at 11 a.m.
Okay.
Okay, that works.
Yeah.
5 to 11, okay.
All right. Position 37 was a plea, and position 38 was null crossed. So we are just waiting on positions 18 Logan, 22 Marshall, 29 Williams, and 32 and 33 Wilson.
May I ask while we're waiting, Judge, there was an inquiry calendar sent over, gentlemen.
Yes, thank you. Yeah, Mr. Cortez Goodman.
We have him in the waiting room. You want me to bring him in, Judge?
Oh, yes, let's bring him in now.
Okay, and also position 10, can you tell me what we did with that?
10, 10, 10, okay.
The third thing she could move that was.
Not guilty, waiver of presence and arraignment.
Correct, further notice for trial.
And I did send that waiver along with the announcements last night.
I would work. He's on probation. Well, that's bad. He's not yet. They're not, they don't stuff around all that.
Cortez Goodman, please unmute and start your video.
Yes, ma'am. Yes, ma'am.
All right, Mr. Goodman, my name is Judge Law, and we are addressing your case that was scheduled for a show cause. 24 CR 799Y. Mr. Goodman, you were accused of simple battery and battery from February 17th, 2024. Your case was you were arrested and you were addressed by the court on February 19th, 2024. You have a constitutional right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, one would be appointed to represent you. Do you have an attorney?
I believe I have one.
Who is your attorney?
I don't know.
Well, you either have one or you don't have one. Do you have a private attorney?
No, ma'am. No, ma'am. I don't have a private attorney.
Okay. Have you spoken to the public defender's office to see if you qualify?
No, ma'am. I
All
have.
right. I'll give you an opportunity to speak to Ms. Vigiletti to see if you qualify for the public defender's office. I will let you know right now that you were given, listen very carefully, and this is for Ms. Vigiletti's benefit too. You need to stop moving your phone around and keep it in one spot.
I'm on the bus, ma'am. I just got off work. I'm sorry.
You're on the bus.
Are you in a moving truck?
Yes,
He's on the bus.
On the MARTA bus, ma'am. I just got off work, ma'am.
Okay. You were required to report to pretrial services. You were given a $4,000 signature bond through pretrial, and you were required to report at least once a week. You apparently have not reported, and the question I have to decide today is whether to revoke your signature bond and have you report back to the jail for bond consideration. So
I have been reported. So I don't know where this comes from.
I don't know, but I'm going to let you speak to, that's why your case has been scheduled for today, because my question was whether I had to issue a pretrial bench warrant for you.
Yeah. My probation officer is Littman. I see him every day. So I don't know what's going on. This
All right, Miss Vigilante, going to put him in, Miss Champion, could you put courtroom 2 and Mr. Goodman in a breakout session, please?
Yes, ma'am.
Is it possible for this gentleman not to be sitting here?
He's on it. He's-
Oh, okay, okay.
And Your Honor, just to let the court know, Mr. Washington is here from the 11th.
Okay. Miss Vigilante, can you get on your device and we'll put you on your device in the breakout with Mr. Goodman. All right, Mr. Goodman, you're going to see a message on your screen to join a breakout room. Please wait there until the Public Defense Counsel is there to address you. Mr. Bartel, you may have a seat, sir. And this is he was on the 11 o'clock calendar, right?
Mr. Washington was number, I believe, 13 on the 11 o'clock calendar.
Oh, we just pulled that.
Is it okay?
And Mr. Washington can come and have a seat in front of the screen.
Now we need to prosecute.
Oh, she's here. You see her? She's on the screen, Miss Falk. All right. This is State versus Craig Washington, case number 24CR000340D. Mr. Washington, you have a right to remain silent. Anything you say about the facts of your case, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Paul Bartel, who's seated next to you. You were accused of disorderly conduct stemming from a January 12, 2024 incident. May I place you under oath for purposes of this plea hearing? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do.
Thank you. Ms. Falk, what's the recommendation for Mr. Washington?
Yes, Your Honor. The state's recommendation is as to all 3 of his cases.
Oh, I'm
And
so sorry. You're right. Yeah. Go ahead. Go ahead.
So we'll start with his case that was on the calendar, position 13, which ends in 0340D. That recommendation to the disorderly conduct will be 12 months probation, 105 days in jail, credit for time served 105 days. That's going to be from January 12th, 2024 to April 25th, 2024. Balance suspended. The condition is that he stay away from Qdoba, QDOBA, located at 5530 Windward Parkway in Alpharetta. His second case is a 22CR006596D case. He was charged with pedestrian and roadway. The state's recommendation is time served, 110 days. That time will be from September 28th, 2022 to January 15th, 2023. The final case is 22CR006599D. That case charged him with willful obstruction, pedestrian in traffic, and pedestrian on the roadway. As to counts 1 through 3, the recommendation is time served, all counts to run concurrent with one another, and that will be 110 days from September 28th, 2022 to January 15th of 2023. The state would ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. And I will state that we did send the offer to Mr. Bartels and Miss Grace. So if she hadn't seen it in her email, I did forward the offer so that she could have all of the documentation for the case numbers and the recommendations. That's all for the state.
And that's the agreement with the state, Your Honor, and we will so stipulate for the purposes of this plea. The court is familiar with Mr. Washington's history, and he is ready to move forward and resolve all 3 of these cases. And just to clarify, it's a suspended sentence. It's not probation. The days that were, so all that is correct in terms of the days and the times that he spent in jail on these charges.
Well, all he has to do is stay away from Qdoba. That's all he has to do. Is that correct?
Yes, ma'am.
All right. Mr. Washington, have you consumed any medicine or alcohol?
No.
And have you understood the cases that were brought against you and your conversations with your attorney?
Yes,
Are you satisfied with your attorney?
yes, I am.
If you are pleading guilty to these cases, you would have to give up your right to a trial. You will not go back to court. You will not face a jury. You will not confront your accuser, and the state would not have to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes,
How do you plead to willful obstruction of an officer, pedestrian darting out in traffic, and pedestrian in roadway in case 22 CR 6599D?
guilty.
Your sentence is concurrent for all three charges. It's to serve 110 days, credit for time served 110 days, and that would conclude the case. How do you plead to criminal trespass in 22 CR 6596D?
Guilty.
Your sentence is to serve 110 days, credit for time served 110 days, and that concludes that case. I just lost that case. Excuse me, just 1 second.
Yes, it is.
How do you plead to one count of disorderly conduct in case 24 CR 340D?
Guilty.
Your sentence is 12 months to serve 105 days. Credit for time served 105 days, balance suspended. So you don't have any additional jail time, but you would have to stay away from the Qdoba Mexican restaurant at 5530 Wynwood Parkway. If you return to that location, you will be arrested again. I have one correction in case number 22 CR 6596D. He has pled guilty to pedestrian and roadway, not criminal trespass.
Correct.
All right, that concludes the pleas. Anything else, Mr. Bartel?
No, that's it, Your Honor. Thank you. Could I be excused?
Yes, Mr. Bartel, you have a good day. Thank you.
You too. See you next week.
You too. All right, medical, who do we have in the gentleman who was seated there? Medical?
Number 18, Logan.
Oh, that's Miss Vigiletti's client. And she, I think, might still be in a breakout.
Yes.
Well, who has Mr. Marshall, number 22? Who has him?
Marshall is also Miss Vigiletti. 29, I have Darian Williams is Mr. McLean. And Wilson is Mr. McLean.
Okay.
Okay. Okay. Okay. My last name is Vigilletti. TTI, yeah.
Oh, I'm sorry, Mr. McLean, you need to mute if Miss Vigiletti is talking in the courtroom.
Thank you.
Mhm.
Your Honor, really quickly, could I get into what the announcement was on position 12? Was that a negotiated plea? Did that actually resolve after I sent the information over? And Your Honor, I can't hear you if you are speaking to me.
Sorry about that. Yes, Mr. Hickson is a plea. He
Okay.
is to stay away from the Marta at Lee Street. He will be staying at the Hope House, and position 13 was null crossed.
Okay, thank you so much. And Miss Grace, if you could just let me know if there were any cases, I'm preparing the null pros on Hickson, but if there were any other cases that were addressed while I had to step out that need null process on the FTAs, please let me know.
Will do.
All right, Ms. Fault, we are hopefully going to be able to address Cortez Goodman. Miss Grace courtroom 2, could you please let Miss Vigiletti know we're ready to address the matter?
I have an announcement. Position number 32 and 33, Mr. Wilson refused to come out. He was up under the covers and wouldn't come out.
Where is he?
He's in his cell. He refused to get out the bed. He refused.
Oh, well, okay. We'll just reset him to May 2nd. I can't force him to come to. Can we bring the jail court iPhone to him at the cell?
The jail iPhone that we have is dead.
Okay. Reset May 2nd, position 32 and 33. He refused to come out to court. Maybe we'll have better luck on May 2nd. Thank you. All right, Mr. McLean is no bueno on Mr. Wilson, 32 and 33. Maybe we'll have some luck with Mr. Williams. Mr. McLean, could you tell Ms. Vigiletti we are ready to address?
Oh, I'm sorry, I was on mute before when I said, yeah, I'll keep the Wilson papers and change the date on them. I'll get hold of Ms. Vigiletti right now.
I'm sorry for the delay. I was able to get a hold of the pretrial services officer, so we were having a conversation. Okay, so we are looking at, is this position 18, Mr. Roger Logan?
Yes.
Okay, Mr. Logan, the prosecutor has agreed to reduce the recommended jail time from 120 days to 60 days. I remember you get double credit in this jail, so the real jail time would be 22 additional days. We got it down from I guess it would have been 52 down to 22. What do you think?
What am I supposed to think? I mean, did we discuss anything in regards to my obligations that are not here?
I did flag that. I did not receive a response yet. Mr. Logan is wondering if reporting remotely is possible because he lives part-time in Columbia.
Oh, I may have missed that email, PD Vigiletti. And that would, so the request is to go non-reporting. Is that my understanding?
I mean, this is a DUI, so there is a lot of requirements. I think it makes sense to report, but a remote reporting being allowed so he can spend time in both locations. His wife lives in Columbia. They own a small store, he tells me.
Okay. So the state has no objection to that once he's completed the terms, the conditions of his probation.
Okay.
Is this a first time DUI?
No.
Well, no, I'm not agreeing to non-reporting.
Would you agree, Your Honor, to remote reporting?
Remote reporting is fine, but there's still got to be, is this Columbia, South Carolina, if I got my geography correct?
This is the country of Colombia.
He's going to the country of Colombia to serve out a DUI sentence?
Mr. Logan tells me he lives part-time in Colombia. Wife is there.
I want to lunch. Go.
No.
Oh.
He has to remain in this country for a minimum of 6 months, and then after that, he can do telephonic reporting or email or Zoom reporting probation if he happens to be in Colombia. But if he takes a plea today, he needs to be in this country for a minimum of 6 months.
Okay, understood. Okay, Mr. Logan, where we're at is 60 days of jail time, but with the double credit, that's 30 actual days. You'll get credit for 8 days, and this probation would go reporting would go remote for your reporting after 6 months.
I had no idea it was going to go like this. I mean, this is from 2019. I haven't had any trouble since.
It's still a DUI, sir. It's still a DUI.
I understand, but I was suspended for 12 months.
12 months because of the Department of Driver Services. They suspend driver's licenses after DUI. But if you plead guilty to DUI today, this will still trigger a 4-month license suspension.
You forgot my name?
I haven't even had time to think about what the other options were.
Judge, could we possibly reset the case? This is the first Mr. Logan is hearing of the updated negotiation, and it does include additional jail time.
May 2nd. And please understand that this is his second DUI. I mean, to allow for non-reporting on a DUI, I will allow for that, but only after he's reported at least 6 months in person.
Yes.
And then, as you know, on a second DUI, that's going to be, I think, a 6-month license suspension, if not more. So he needs to understand that also. That is not us. That's the Department of Driver Services.
Yes,
I mean, if he wants to drive in Colombia, that's entirely up to him, but that's only after his term of actual reporting has over. And then he needs to do all these fines and classes and everything before he leaves for Colombia. So everything needs to be done in the first 6 months of reporting.
Understood. Thank you, Judge. Mr. Logan, I'll come speak to you again, okay? We'll talk about the details of the terms again, okay?
I can just go ahead and I'm considering just going ahead and accepting it because it doesn't seem like anything's going to change.
Yes.
Actually, before anyone else says anything else, let me just kind of, not to pile on PD Vigiletti, but I actually just saw that he has a dormant bench warrant on another case for DUI. That was from December 14th of 2019.
What case number is that?
22 CR 000995D.
So another DUI case.
Ms. Spock, could we actually, I completely forgot. I did actually want to flag this first. I did see that case and I spoke to Mr. Logan. That is, I believe, a bind over from Forsyth County, if I'm not mistaken. Mr. Logan told me he took a plea in Forsyth County for that charge. And so I just want to make sure that we're not, we don't have something open here that should not be open. I reached out to Forsyth County, but you know, we're operating on such a tight timeline.
I totally
Just-
understand.
Just 1 second, folks, just 1 second. Medical, please mute. We're having too much background noise. Okay, that case that Miss Falk has just referenced, it cannot be a bind over from Forsyth County. Unless he was arrested in Fulton County, unless the incident occurred in Fulton County. So let me just look at the results of the paperwork in that case. So this is another DUI arrest from December 14th, 2019. Just about almost less than a month, well, yeah, just over a month after the arrest in this case that we have. So that's 2 open DUI cases.
I'm
And-
sorry. I
Okay.
apologize, Judge. I misspoke. He told me he took a plea in Fayetteville. And that case is a bind over. I'm sorry.
And so that's why I get to look at the paperwork, and this is from
Union
November 5th.
City is what I'm seeing.
I don't have the bind over documents. Let me see.
I do.
discovered here.
I will forward them to all parties. What I would say is either way, a continuance to May 2nd needs to be done. He's going to be serving more time anyway, and we need to sort out this second case.
I completely agree. Thank you, Ms. Fox.
Just 1 second, please.
I don't have my computer.
They brought it down, they have not brought it down.
Anthony Russell.
Did you get brought down, no?
Yeah, no, yes.
They done him on zone, they do him on zone.
All right. I'm not certain whether this plea was, I have this document that was part of the paperwork. And it looks like Mr. Logan checked mark not guilty. So if you want to check with the municipal court of Union City on the citation numbers 19-600, 651, 652, and 653. It looks like when he filled out his acknowledgement of rights and waiver of right to counsel, his plea form, that at the end of it, where his signature was, he checked mark not guilty.
I did see that, Your Honor, and then when I spoke with him, he told me he took a plea 90 days ago. And so, I just don't have any documentation and of that, so I'm just not sure, 100% sure what he took a plea to 90 days.
So it puts a whole different picture on Mr. Logan's cases. This is not just 1 DUI, this is 2 DUI cases. And they're both open. And both sides need to reevaluate what they're offering, Mr. Logan. And I will see y'all on May 2nd for this.
Okay, thank you.
Both cases, for both cases. So we're gonna reset Mr. Logan for 21 CR 5448Y and 22 CR 000995B.
And PD Vigiletti, I sent over the bind over paperwork to you, Judge Law and Melissa Grace. So Miss Grace could add this case on to the second as well. So we can just address both cases.
Sounds good. Thank you.
All right. Thank you, Mr. Logan. We are concluded. We'll see you on May 2nd. All right. Have we addressed Mr. Marshall? 22?
Mr. Marshall, I just wanted to update you that, the state is agreeable to your probation terminating once you pay your fines, okay?
Yes.
So I believe your Honor will be moving forward with a plea today.
All right. This is State versus Tony Marshall, 24 CR 1838F. Mr. Marshall is accused of willful obstruction of a law enforcement officer, driving while license suspended or revoked, a seatbelt violation, driving on a suspended or canceled registration, and violation of the Georgia hands-free law. This is from July 6, 2023. Mr. Marshall, you have the right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Vigiletti. Are we proceeding with a plea? Yes? All right. Mr. Marshall, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Okay. Yes.
Thank you. Ms. Falk?
Yes, Your Honor. On the willful obstruction, it's going to be 12 months concurrent with count 2, a $300 fine. On the driving while license suspended, it will be 12 months served 28 days. The defendant has served 14 days from April 11th, 2024 to today. Balance suspended with a balance probated with a $500 fine. There is a 1-year license suspension associated with that. On the seatbelt violation, it's 12 months probation concurrent with count 2 and a $15 fine. On the suspended registration, it's 12 months probation concurrent with count 2 with a $135 fine. And on count 5, the driving distracted, it's 12 months probation concurrent with count 2 and a $50 fine. The state has agreed to terminate his probation upon the payment of all of his fines, but we do remind the defendant that his license will still be suspended for 1 year under the driving while license suspended or revoked charge. The state would ask the defense to stipulate to venue factual basis and identification for the purposes of this.
So stipulated. And Mr. Marshall, I know we talked about this yesterday, but I'll just say again, that suspension, there's nothing this court can do about it. That comes from the state.
All right.
When she says the state, she means DDS.
Yes.
So
I'm sorry.
it's not my office.
I understood.
It's the Department of Driver Services.
All right, please unmute medical. Mr. Marshall, if you decide to move forward with this plea, you'll be agreeing to pay a $700 fine and your license is suspended for the next 12 months. Is this something you'd like to proceed with?
Yes.
Your attorney has already entered the necessary stipulations. Have you consumed any medicine or alcohol recently?
No.
Have you understood the proceedings so far?
Yes, I have.
Are you satisfied with your attorney?
Yes, she's awesome.
And if you decide to plead guilty to these traffic charges, not only will it add points to your driving history, but it will also trigger a 1-year license suspension. In addition to that, if you decide to plead guilty, you have to give up your constitutional right to a trial in front of a judge or a jury. You will not get the opportunity to confront your accuser, to challenge the evidence brought against you, to present any defenses and arguments, and have the state carry its burden and prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to the 5 traffic charges, willful obstruction of an officer, driving while license suspended or revoked, a seat belt violation for an adult, driving on a suspended or canceled registration, and a violation of the Georgia hands-free law?
Guilty.
On the willful obstruction, your sentence is 12 months concurrent to count 2 with a $300 fine. Oh, his fine is $1,000. Okay, excuse me. On the driving while license suspended or revoked is 12 months probation to serve 28 days, credit for time served 14 days. Balance probated to pay a $500 fine. On the seatbelt violation, 12 months concurrent with count 2, a $15 fine. On the suspended registration is 12 months concurrent with count 2, $135 fine. And the Georgia hands-free violation is a 12 months concurrent with count 2, a $50 fine. Your total fine is $1,000. You will report to probation on Monday, April 29th before 3 p.m. And you will be on probation for as long as your outstanding fine, court costs, and probation fees are outstanding. If you pay all your outstanding fines and fees, your probation will terminate. However, your license suspension will continue because that is authorized by the Department of Driver Services. Do you have any questions, sir?
Your Honor, after I leave here, I will be going to Carroll County for a probation hold. So reporting on Monday will be
not possible.
Right.
Okay. So as long as you resolve your holds and you are released, then you must report to probation on the first available business day, and that would be on a Monday, a Tuesday, or a Thursday. So if you're released 2 weeks from now, you need to immediately come back to Fulton County and report to probation. No delays.
I just want to make sure that there's no warrant put out on me because that will again violate my probation.
Are you traveling to Carroll County on your own, or are they coming to pick you up?
They will come get me.
Okay, then probation will be well aware. Currently, it's still in custody. Thank you.
Thank you, Your Honor.
Okay, Judge?
Yes.
Ms. Falk, that was 12 months to serve 28 days. What's the credit?
14 days.
Thank you.
All right. Medical, do we have any other cases?
Yeah, we got Williams.
Williams?
Lee Williams.
Is this Darian Williams? Are you Mr. Darian Williams?
Yes, ma'am.
Mr. Williams, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and your counsel is Mr. McLean. He's charged with battery, family violence, and criminal trespass. How are we proceeding, Mr. McLean?
It's a negotiated plea, Your Honor.
All right. Mr. Williams, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Falk?
Yes, Your Honor. The state's recommendation is 12 months served, 60 days, credit for time served, 15 days. That's going to be from April 11th, 2024 until today. Balance probated, family violence intervention program, 40 hours of community service, no further violent contact with Shaquilla Williams, and no firearms. On count 2, the criminal trespass, the recommendation is 12 months probation concurrent with count 1. We have spoken with Ms. Williams, and she did state she agrees with the plea offer. She did state she will not be on Zoom today, but I would like to sound for her out of abundance of caution. Ms. Williams, if you are here, please turn on your video if you would wish to speak. The state would ask the defense to stipulate to venue factual basis and identification for the purposes. That's all for the state.
For said purposes, we do so stipulate.
Okay. Mr. Williams, have you consumed any medicine or alcohol? Mr. Williams?
I take medicine.
Okay. And are you still able to understand what's going on?
Yes, ma'am.
All right. And are you satisfied with your attorney?
Yes, ma'am.
If you decide to plead guilty, you would have to give up your constitutional right to a trial. You will not get a chance to come back to court to challenge the evidence brought against you, to confront your accuser, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
Are you entering a plea of guilty freely, willingly, and knowingly?
I didn't hear you. Your thing was breaking up.
Are you entering a plea freely, willingly, and knowingly?
Yes, ma'am.
How do you plead to battery, family violence, and criminal trespass?
Not guilty.
All right. So if you're pleading not guilty, we will have a trial in your case. Mr. McLean, your client has pled not guilty.
I've heard, yes.
All right. So we will, Mr. Williams, as you have entered a not guilty plea, the case will be scheduled for trial. Please understand that at the time of trial, the state has the burden to prove the 2 charges against you beyond a reasonable doubt. If they do prevail, you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine.
Excuse me.
Yes, sir.
Mr. Williams, do you understand what we're doing today? That's a
Okay.
shaking head as opposed to a nod.
All right, we will see him on May 2nd. This will not prejudice the sentence as indicated. And Mr. McLean, hopefully he'll be able to have a better understanding of what he wants to do. I'll defer on an arraignment until then.
Very good, thank you.
Mr. Williams, we will see you on May 2nd. Thank you.
Yes, ma'am.
All right, Judge, that's everybody. Thank you.
Thank you, sir. All right, that brings us to Ms. Vigilante, your client, Mr. Goodman. Cortez Goodman, please unmute and start your video.
Judge, when I spoke to Mr. Goodman, he said he's been reporting regularly to Officer Linton. He was describing in pretty significant detail how he's reporting to Officer Linton. I gave Officer Linton a call, and he did say that Mr. Goodman has been reporting, and that is not actually the reason for the issuing of the warrant. He told me there should be a violation of compliance report attached to a warrant. I don't have to give that documentation. I've looked everywhere I can think to look.
I'll send it to you.
Thank you so much. So he said that the primary issue is that Mr. Goodman has picked up a new charge in the city of Atlanta, a possession charge. Mr. Goodman is telling me he believes that charge is dismissed. Officer Linton also said that there has been a violation of curfew conditions. Unfortunately, I don't have the paperwork. I don't have the paperwork for whether this new charge was dismissed. I don't have this report that the officer was referring to. I'm wondering if it's possible to reset this issue to give me a chance to take a look at everything. Because Mr. Goodman's telling me that this charge has been dismissed. If it was through the city of Atlanta. It's not something I have immediate access to.
I just emailed you the report. This is a report by pretrial officer on March 25th, 2024. It's submitted to the presiding judge, who was sent to me for consideration of a bench warrant on a pretrial bench warrant.
Understood.
Goodman was released to intensive pretrial supervision level 4 on a $4,000 signature bond. He was reporting. However, he was arrested again on new charges while he was out on a signature bond to pretrial. Getting arrested while you are on a signature bond can result in your signature bond being revoked. He was also placed on a 6 p.m. to 6 a.m. curfew and was required to phone report weekly. In addition to being available for field visits, Mr. Goodman has had the following curfew violations: March 3rd, March 8th, March 10th, and when he received his new charges. In addition, he failed to report on his phone reports February 9th and March 14th of 2024 and missed his field visit on March 6th and March 20th. Based on that violations, the pretrial services is asking me to issue a bench warrant.
And PD Vigiletti, I'm looking at the municipal court record right now. It looks like he has 3 open cases in municipal court, one with an offense date of January 19th, 2024 for possession of marijuana. He entered a guilty plea, one for possession of walking in a roadway and possession of marijuana on March 6th of 2024. He entered a NOLO plea to those, and then one for April 2nd of 2024, drinking in public, which is still open.
And the condition of the signature bond was no drugs, no alcohol. No illegal drugs and no alcohol. And that was signed on February 19th, 2024 by Judge Morrow. That is why instead of signing off the bench warrant super sponte, which unfortunately is done procedurally, I instead required him to show up today to show cause why I shouldn't be issuing the bench warrant. I'm not doing a reset. He's well aware of his open case, the rest he's had.
Understood.
Anything to add, Ms. Vigiletti?
The only thing I'll add, Officer Linton did say, you know, he feels that treatment would be the best place for Mr. Goodman. And that was really the entirety of our discussion.
All right. I'm going to continue him on the pretrial signature bond. He is going to be subject to a screen by pretrial twice a month for illegal drugs and alcohol. Mr. Goodman is not allowed to consume any illegal drugs. In Georgia, marijuana is still considered an illegal drug. So no marijuana, no weed, and no alcohol. If he fails any of his screens, his signature bond will be revoked. Mr. Goodman, do you understand?
Yes, ma'am.
All right. And also, within 30 days from today, you are to submit yourself to an alcohol and drug evaluation and comply with any treatment that's required. And you will report to pretrial once a week. You'll be subject to 2 screens.
Yes, ma'am.
If you violate those screens, or if you don't do your alcohol and drug evaluation within the next 30 days, your signature bond will be revoked and you'll have to pay for your bond the next time.
Yes, ma'am.
Thank you.
Thank you, Your Honor.
All right, Ms. Vigiletti, I'll do the amended bond order on that.
Okay, thank you, Judge.
Anything else, folks? All right, Ms. Jackson, if you could let Ms. Mann know that I'm going to deny the request for a bench warrant and instead issue an amended bond order for this case.
Yes, Your Honor.
Thank you.
Thank you.
Sounded good.
All right, and please remember, Mr. Goodman, if you have any questions about your field visits and your weekly telephone reports and so forth, you need to go and talk to pretrial. Because if you violate that, I mean.
Who do I talk to, Your Honor?
Your pretrial officer. Go to pretrial services.
Yeah,
my probation officer lent me.
Linton is his name. Yeah, give him a call.
Okay.
You're not on probation. You're on pretrial. You call that pretrial officer.
Yes, ma'am.
All right. Thank you. You're free to go. All right, folks. I think that concludes our calendar.
Thank you, Judge.
Thank you,
Judge. Have a great one.
Judge, I'll be sending the paperwork over to you.
Thank you, Ms. Grace.